mechanisms from a practical perspective. In today's session, we will first discuss the Singapore Convention on Mediation and its potential role in the rise of institutional mediation in India, followed by how beneficial it could be for institutions to diversify into offering multiple centralized ADR mechanisms. To shed light on these themes, we have some of the best practitioners and academicians from across the globe with us today. It is with great pride that I would now like to introduce and welcome to our esteemed panelists for this session. Firstly, we have with us Mr. 𝗓𝗵𝗲, who is a partner at 𝗧𝗵𝗵𝗂𝗧𝗵𝗂𝗧𝗔, a leading firm specializing in dispute resolution in India. We also have with us Ms. 𝗬𝗓, who is also a partner at 𝗬𝗵𝗲 Partners and is an impaneled arbitrator at Center for Mediation and Conciliation, Bombay. Next, we have Dr. Rajesh Sharma with us, who is a senior lecturer, legal and dispute studies, criminology and justice at RMIT University, Melbourne, and an adjunct professor at School of Law, City University of Hong Kong. Also with us, we have Mr. Pranav Budilal, who is an associate counsel at Singapore International Arbitration Center. Ms. 𝗵𝗲 Bishnoi is also with us, who is a member at Center for Trade and Investment Law, India. We also have Mr. 𝗧𝗵𝗲 with us, who is the head of Hyderabad International Arbitration Center, which is a newly established yet extremely successful venture in the institutionalization of ADR. And secondly, we have Ms. Laura Jimenez, who is an associate at Asher's Law Firm, one of the leading firms in the UAE. And lastly, we have with us Mr. Anubhav Sarkar, who is a partner co-founder at Triumvirate Law and offices in Bangalore in New Delhi. He extensively practices in international commercial arbitration and corporate commercial laws, and he is also a visiting lecturer at various law schools. I now hand over to Mr. Sarkar to guide the session as a moderator through his impeccable expertise and knowledge on this subject. Thank you.
Thank you. Thank you so much. And I welcome everybody present here today. I mean, it's truly great to have such a great August panel with us. And the idea today would be to essentially discuss through these themes and try to come out to a conclusion which academics and lawyers often don't arrive at. I feel like Elizabeth's sixth husband, being a moderator, I know what is expected from me, but I really don't know how to do it differently. But I would try to do my best with that. Today's broad themes that we are supposed to discuss are essentially two. I'll first concentrate on the first theme that we have at hand, that is the Singapore Convention on Mediation and its potential role of the advent of institutional mediation in India. Just as a background to our viewers or our participants who might not have a basic idea of what the Singapore Convention on Mediation might entail, the Singapore Convention on Mediation is a multilateral treaty offering a framework for enforcement and invocation of international settlement processes and mediation in international agreements. Now, with the current invocation of the draft Mediation Bill in India on 5th November 2021, it poses an interesting scenario in front of us to see how these two prospective charters interact and what is the future of mediation and so as to say institutional mediation in India. Without further ado, I have a sequence that I would like to follow, but there is no measures for the panelists to stick to that. I would first like to open the floor to Mr. Sharma to give us a academic's perspective on what he thinks has been the journey of mediation in India per se. So, as per his experience in academia.
Thank you, Anubhav. Indian mediation, well, all of you know there because you are working, but I can only tell you from the outside what we see and what we were expecting. I will just say that we have to see the mediation law or the mediation development now in India from the Singapore Convention's eyes, that what we have achieved and what we are going to achieve. So far as earlier the mediation was there was no structure and there was no law. So it was an ad hoc, but there were several agencies in India and institutions which are running and which have done, they have done very good job in developing the mediation. So whether it's in Bangalore or in Hyderabad or in Kochi, they have all these centers. But what I saw that when the Singapore Conventions was deliberated in UNCITRAL, because I was involved in that one since 2015 when it started, and I joined as an expert in that one. So what we were seeing at that time, that we wanted the Indians and other jurisdictions to come forward with their suggestion and other. But to my surprise, there was not many Indian delegation. One was the government delegation, and there was another observer over there from the Society of Construction Law. They were there. But the contribution from India was not very strong, I can say. Though India was rapporteur in one of the session or one time in that one, but it didn't come very much in that one. For several reasons, it happened. But what is good about that when Singapore Convention was adopted, then we were expecting that it will pave the way for many countries, not only India, but many countries, to establish a structured mediation system in their country. And that was the idea. And therefore, with the Singapore Convention, even the 2000 conciliation law was changed into mediation law, and the enforcement section was added. With UNCITRAL and other, we had several programs. We went to the Papua New Guinea and other. Many countries had no idea. Even in Australia was not far, in that sense, very much involved. Because when I came to Australia and I asked whether they are involved or not, to my surprise, many of the mediators were not involved in any of these discussions. So the development was not happening. But what we expected from Singapore Convention first is that the country will sign. So Singapore Convention, in Singapore, when in the very first days, 46 countries signed, it was a very good sign, and India was included. 2 days ago, we got the report that India is not signing, but fortunately, India signed that. It was a very good, at least we could keep our head high in that sense, in that meeting. Second, we wanted with this one that every country will have a domestic law on mediation, or a standalone or a structured mediation law. So coming to this new mediation law in India, at least it's started. So this is one example. Third, we wanted to develop, if the country does not have a centralized institution, then at least it should develop some institution or some institutional aspect of it, though it was not required, but it does help in some extent. Another thing we wanted for the Singapore Convention related, that in many countries, we do not have any mediation standard for mediators and mediation. Or even if we have, it is not very universal in that sense. And the fifth aspect is that the conflict of interest in mediation. Generally, we borrow the concepts from arbitration, but we need a plain slate or the clean page to start writing on that. And the Singapore Convention has paved that way to discuss about it. It's not an easy task, but it has done it. And what at the end, we want for every country, and particularly the young lawyers, to really acquire the expertise in enforcement of this settlement agreement, because this is going to open a new practice area. Like New York Convention, you should also acquire this knowledge, and the Singapore Convention will help. India, by adopting the mediation law, at least trying to do something, and we are hoping that all the young lawyers will try to develop the expertise on that one. So this is my brief opening remark related to mediation.
Thank you, Doc. Thank you, Dr. Shah. That was indeed insightful into the perspective how the genesis of mediation came about in relation to the Singapore Convention on Mediation. But what the question that brings about is that what is essentially the perception of Indian clientele towards mediation? And maybe Ms. Bal could throw some light on that. That in your broad expertise of practice, what has been the perception of the Indian clientele, or the perspective of the general people towards mediation? Do they normally consider it to something to be effective, non-effective, or are they aware of it, unaware of it?
So I think about 5 years, 6 years ago, at least, when you spoke about mediation, people always thought that you were talking about meditation. And that is a standing joke, that among me is it meditation that we talk about rather than mediation? But if you look at India itself, and when you talk about mediation in India and how clients are sensitized towards mediation, I think jurisdiction also plays an important role. So there are certain states where mediation through not just because the courts are driving mediation far more in those states than the others, the clientele there is far more aware. Because the legal fraternity itself more aware, so they are able to educate their clients. So there you see mediation being used in terms of contracts that are coming out of those states, and in courts, and among, even parties talk about settlement of disputes through mediation much more there than other states. But in some states, you still have clients and you talk about mediation, they're like, I don't have a weak case. Why should I settle? So the perspective is still that, I have a weak case and therefore I need to look at mediation, rather than looking at mediation as part of a dispute strategy. And, just adding to what Mr. Sharma was saying, that, mediation actually has been in India for several years. If you look at even in terms of a structure and form, while people talk about it, we're just starting to talk about it, but actually conversations on mediation, while the Supreme Court got involved and set up the MCPC around 2005, which is also 15 years ago, it actually started even earlier. You had in 2002, amendment to CPC happened. In 96, when you had the new arbitration, conciliation, even though it's used conciliation, but at least the tools and mechanics of having a settlement by parties communicating with each other was sort of introduced. And you've had, mediation, conciliation, the words being interchangeable, even used before that. But if you look at it, we've been around for over 20 years. We've had mediation around. We have model laws for ADR, which were also introduced around 2015, 16, if I'm not mistaken, which even various state high courts have adopted as well. But still, from there to say it on record, on paper, we've had mediation, we've had conciliation, we've had facilitated, negotiated settlements between parties in our statute books, to today, where we're seeing Singapore Convention. And what Singapore Convention has done is it's actually made parties more aware. The fact that there is mediation, it is a form of dispute resolution. At least people are talking about it. But I think it's still a journey. We still have to see, because we only have 8 countries who've ratified it so far. We only have 55, unlike for New York Convention, where we're looking at about 168 odd countries who've ratified the convention till date, and they're still ratifying, because I think that the last ratification happened earlier this month itself, earlier November.
Right.
Yeah.
Right. I mean, with that, I mean, I absolutely agree, Ms. Bal, that that the concept of mediation has been in India for a long period of time. And I was in fact reading a book recently, in which it was by an historian, and he mentioned that the concept of mediation and alternative dispute resolution in India dates back to the 16th century and 15th century, where essentially the basic structure of a panchayati raj would set up, and if there was any disputes that would emanate, you had to bring it to them, and they would try to negotiate or mediate between the parties. And if there was something adversarial, the punishments would be to the effect that you are not allowed to participate in next year's 𝗷𝗵𝗲 celebrations. So that's how it would be. But what you also said is very notable, that the definition of conciliation and mediation have been used interchangeably. In light of that, I would like to bring Mr. Mirza into the discussion. The draft mediation bill and the Singapore Convention on Mediation use the term mediation and conciliation interchangeably. Mr. Mirza, if the difference between the two terms was essentially as artificial as opposed to the decision of the Supreme Court, I think in 𝗬𝗵𝗲 versus the Union of India, would you essentially want to think that a mere amendment would have sufficed to the Arbitration and Conciliation Act, rather than bringing in a standalone act to this effect?
See, there are various views on this question. Of course, I have a separate view. So I think there was a necessity or a requirement for getting a separate act for this purpose, because what we were, like it rightly pointed out, that it's usually used interchangeably, but has a lot of difference. So conciliation is more formal. If you see, mediation was not that formal till about recently. Now we will have some formality attached to it, and therefore there is some amount of seriousness that will increase. Rightly pointed out by 𝗖𝗍 that 5 years back or 6 years back, it was not so usual for people to go for mediation. Rather, I'll talk about my personal experience. I've been 11 years in the profession, and when I initially joined, We only used to go for mediation just for a formality if there was a family matter or a partition suit or something. So juniors were saying, just go and see what's happening and just sit, have some tea, coffee, and come back. Mediation center in Delhi High Court used to give free coffee, so we used to go there for that also. But now with time, what has happened in the past 3, 4, 5 years, also after coming of the Commercial Courts Act, which made the pre-litigation mediation compulsory, we are seeing more and more commercial matters going into mediation. Of course, this COVID and all has also made clients conscious about the expenditure they are making in litigation, or rather arbitration. Earlier, arbitration was seen as a cost-saving tool or a mechanism, but we practitioners know how effective has that been and how cost-saving has that been. So clients are also getting educated in the sense that they also want some more methods as to how to save money plus time. So a separate legislation being brought is a welcome step in my view, in my personal view. A few people, like you, Anubhav, rightly pointed out that merely an amendment would have sufficed, but I think a separate codification may really help getting people to a separate track and make them feel that yes, mediation is as serious and as important as other ADR tools are.
Thank you, Gauhar. I think that makes sense. And yeah, I mean, I would also prefer a new act rather than an amendment, because the perspective towards mediation in this country, in my opinion, needs a change, and then there is no better way other than bringing it as a separate act and a standalone act in its all seriousness. I would like to bring in a different perspective to this debate right now, and I would like to bring in Laura into this discussion. She's based out of UAE, and I would like to understand that what is the perspective of mediation as an ADR mechanism in practice outside India. So, I mean, what are the perspective that the clients have towards the mechanism, and what has been the efficacy of the system there?
Sure. Good morning, everyone. Well, the approach of parties in the UAE to mediation and in general dispute resolution mechanisms prior to get to the arbitration stage is actually it's actually very good. Parties often include a mediation stage prior to an arbitration in their dispute resolution clauses, which is, as a private practitioner, a move forward and towards reliance on the mediation process. However, what we experience in practice is that more often than not, mediation is included in the multi-tier arbitration clauses as a way to like as a step to tick off, rather than actually pursuing to solve the disputes in mediation. So what we will face in negotiations and in mediations is that parties just want to meet, but they don't really have the goal to sort out their dispute. So they will just send a letter to the other party aiming to solve the dispute through mediation, but they will just wait until the period is over, so for them to start the arbitration. That being said, the UAE legal framework is very mediation friendly. And this year, in fact, the government of the UAE issued a law in mediation. And we are yet to see how this is put into practice. But undoubtedly, the Singapore Convention is really the missing piece when it comes to the enforcement framework in mediation. We do have here in UAE 2 different centers. Well, one of them is a center which is just for mediation procedures and mediation cases. And there is a federal law, which is actually quite an old federal law issued in 1999, which enables the setup of committees and conciliation centers, which upon issuance of a mediation order, we call it here order, although it's not an order, parties can take it to a court and enforce it. Again, in practice, in my experience at least, I have never faced or experienced or sat in a mediation in which we have been able to take the mediation order to court. And regarding the settlement of disputes center, which is how we call the mediation center here, we have had one case, and the only challenges that I see when it comes to centers with offering mediation services is I see that there is a lack of education in the system and how mediation should work. It's definitely a very different system from an arbitration. And I think parties as well as institutions need education in it, and mediation in general needs promotion. And I'm hoping as a practitioner that the Singapore Convention brings us all together, and mediation can get a little bit more of a strong part in the alternative dispute resolution processes. Unfortunately, I would like to add that unfortunately the UAE has not signed the Singapore Convention yet. The only the only party, Middle Eastern party that has signed is Jordan. We are not discouraged that this number because of this number, because really, like, the New York Convention at the very beginning was only signed by 3 Middle Eastern countries, and nowadays, you know, like it's the convention. So we're hoping that in time, the UAE can sign this convention. I think Qatar and Saudi Arabia have also signed, actually, yeah. Saudi, Qatar, and Jordan, yeah. But at the beginning, I was saying at the beginning, the New York Convention was only signed by Jordan. So, you know, this initial reception doesn't mean that we might not get on board soon.
Right, right. Thank you so much, Laura. That's definitely a very fresh perspective from another country's scenario that exists there. But on that, I would like to pick out one point from there, that is the non-signatory bit. As we understand that, you know, India, China, and the USA are all signatories to the convention as things stand, and they form a substantive portion of the world's GDP. But as things also stand, the UK, the Australia we are waiting for these, you know, superpowers to also sign the Singapore Convention on Mediation. I would now like to hear from Pranav. You know, what implications could the non-signatory states or bring to the authenticity of, you know, Singapore Mediation Convention, you know, in terms of, you know, and what can be the mindset of essentially of the countries that are not becoming signatories to the Singapore Convention of Mediation? Are there any you know, hindrances that is stopping them, or are there any lingering, you know, negative thoughts that currently exist within the framework that is, you know, destabilizing the whole process? If you could shed some light on that.
Thank you, Anubhav, and it's a pleasure meeting everybody here. So while I won't presume to know the mindsets of countries that are non-signatories, but what I can tell you is that in Singapore, at least, what you look at is you see the diversity in culture to litigation and mediation that is in each jurisdiction, and that plays out interestingly from what Ekta had said, because even in Indian parties, the approach to mediation is very different, and whether you view it as a sign of strength or a sign of weakness is something that becomes very important from a user perspective. So you also have counsel from each of these jurisdictions using it differently as a matter of dispute resolution strategy, along with the other modes that are. With SIAC, we've always had the 𝗏𝗵𝗲 protocol. So if there are users from non-signatory states and it's an SIAC clause, parties can always use the 𝗏𝗵𝗲, where the reference is to arbitration, and then the parties can mediate the dispute, and then a consent award can be passed under as an SIAC award, and that can then be enforced under the New York Convention regime. So for users who want an enforceable mediation settlement, that's one way out that at least the SIAC offers for users from these different countries.
Okay, thank you, Pranav. I think you know, that gives us great perspective into the holistic structure that currently prevails in Singapore and what we can expect going forward from the Singapore Convention of Mediation. However, what we need to also bring into consideration is that what can be the applicability or how will be the adaptability of the Singapore Convention of Mediation in regional dispute resolution bodies. With that, I think the best person to discuss that would be 𝗬𝗵𝗲. 𝗬𝗵𝗲, if you can kindly throw some light on the fact that how is your approach to the Singapore Convention of Mediation, and how do you see that in sort of in its applicability and functioning together with the Hyderabad Chamber of International Arbitration?
Thank you so much for that question, Sakar. So HAC, Hyderabad Arbitration Center, we do have published our own mediation rules, and they were published, in fact, prior to the Singapore Convention has happened. But in any case, we have taken guidance from the premier institutes such as the Singapore International Mediation Center, and a little guidance from some practitioners from the UK jurisdictions as well while framing our rules. Having said that, practically, we have not administered any mediation as such under the rules of HAC. But as a practitioner, I did conduct mediations as a mediator and a co-mediator in some cases. And from an institutional perspective, I would say that I have a lot of reservations against Chapter 7 of the Mediation Bill, specifically of the Mediation Bill. What basically it deals with the institutional bodies. And they call the institutions rather with a very interesting word such as service provider. So now we become the service providers, and the service providers need to be registered, and there are certain criterion which will be prescribed apparently, which are not really enumerative in the bill itself. So I am really looking forward to as to how my HAC institutional perspective, how each person will get an accreditation, if I may put it that way, from the Mediation Council. Now, what happens here is that although I do encourage and I agree with my co-panelists that we need to have a specific legislation instead of having a mere amendment to the existing Arbitration Conciliation Act. But I'm a strong believer of the neutrality that is involved and the independence of this entire practice, which is the beauty of it, is what I would say. When I say impartiality, neutrality, independence, I'm also speaking it from the perspective of the end user, that is the clients. They come to mediation for one reason and one reason alone, that is the costs that are involved and the time that would take probably to resolve the disputes. And although some would disagree with me that the costs are also becoming a little higher, because now we are actually adding another step of mediation, then arbitration, and then enforceability. But the angle that I'm trying to bring from an institutional perspective is that the practitioners like ourselves, like all of us who want to act as a mediator, and the institutions who want to render this service to this thing, will have to again be compliant with certain additional categories or criteria that will be prescribed by a body sitting centrally located probably in Delhi, and who are going to be the stakeholders. Now, I see the composition of the council, the Mediation Council, but the things will not probably move as quickly as possible, is what I believe, and that has been our experience as well, being practitioners. So one has to wait and see as to how it's going to affect the end user, the clients, as well as the practitioners. But the enforceability aspect, we're coming to the Singapore International Convention. Of course, the settlement agreements that will be probably entered into by the parties during a mediation that has been conducted in an institution, rather service provider, administered by a service provider, will have an international enforceability such as the New York Convention. Now we have the Singapore Convention. But one has to wait and see, and it's going to be a learning curve for us as well as to how we will be required to meet certain standards. The standards seem to be undisclosed as of now, and how we have to take that into perspective.
Thank you so much, 𝗬𝗵𝗲, and I think that it was a completely unequivocal assessment of the current scenario, and we really appreciate that. And we understand that the mediation process as such requires a a significant journey to reach where we wanted to reach as a method of ADR. However, I mean, we who are practitioners and academicians in the process will have to contribute to it greatly, and I think that is the whole idea behind this session, to essentially discuss, ideate, and see what we can take forward from this. And I appreciate. Thank you so much.
Thank you.
I would like to bring Apoorva right now to the session. Apoorva, I mean, whereas Article 1 of the, we see that Article 1 of the, the Singapore Convention essentially limits the scope of the applicability of the Singapore mediation of mediation on Convention on Mediation. It essentially, if I may just read it out for you. I mean, it basically, the convention limits the scope, providing only international settlement, providing that only international settlement agreement arising out of mediation to settle a commercial dispute. Now, do you not think that suppose now if there were parties which were basically domestic in nature per se, and were considering a standard benchmark to consider, to take forward its mediation mechanism, the applicability of such a mediation system where bodies could imbibe the SCM rules into their into their rules, and make it a standard procedure rule, that the whole process fails in terms of making the process much more uniform going forward.
I think regarding this, this was done because of the diversity and keeping in mind the diverse practices that have emerged regarding mediation in each country. And one of the problems that has been faced is that how do you make sure that the policy space for each country is preserved when coming up with the enforcement mechanisms regarding whether mediation or any other. So now, of course, there is model law for arbitration that came out in 2018, and one can obviously extend it to the domestic regime, have a uniform regime for both the international mediation settlement agreements and the domestic ones. But I think in order to reach an agreement, which a bare minimum threshold, which can be agreed by all the parties, the maximum number of parties, it was thought necessary that the domestic space, the domestic policy space should be preserved. And one can see that why this should not be like it would have been more ideal if the domestic space could also have been covered. But sometimes you have to compromise a little bit in order to, actually reach an agreement. Considering that India has not signed the Exit Convention when it comes to a lot of objections it has. While it did sign it was like one of the first parties to sign the Singapore Convention on Mediation. I think this strategy has been successful, and I'm truly believe that we'll see a lot more countries joining in and signing the convention in next few years.
Thank you. I think Mrs. Bal also has an opinion on this, if you would want to join in, Mrs. Bal.
So, so the thing about mediation is, unlike in arbitration, it's not a structured process. It's about how the parties choose, and that party autonomy is extremely critical to the process. So, in fact, one of the criticisms of the mediation bill itself is that they're trying to put in too many processes, and that could derail the process itself. So because there's party autonomy, and of course neutrality, as Shravan pointed out, is extremely critical. But if those are the key elements of a mediation, so if you regulate too much, you will cease to make it a mediation, because the process takes over, and then you're defining what a process is. And the beauty of mediation is that it's parties determined. The parties set up the process, the parties set up the procedure. As long as the mediator is neutral, as long as there's confidentiality in the process, of course, and then you're not, you're talking about, you don't mediate on something which is illegal, etc. But apart from that, there is nothing else that binds or guides how the mediation should flow. And that is left to the parties to figure out, and they work with the mediator. So unlike in arbitration, where you would have pleadings and there are cornerstones in it, mediation does not have those boundaries. So if you put too many processes, it will derail the process. And that, I think, was also the challenge of the Singapore Convention. They had to make sure that while they put in elements of recognizing country elements, they also had to respect the field and space of mediation and make it as procedurally and not as process driven as they would do for other conventions.
Thank you, Ms. Bal. I mean, on that light, I think, I mean, I'm just like, intrigued to bring in Article 4 of the convention, which implemented in a national act in India would bring its difference, where the mediators can become uncomfortable to basically shift from the current procedure where the media cannot be asked to give evidence before a court. However, Article 4 of the current convention says differently, that they might be called to clarify their confirmation of the settlement and so on and so forth. So in light of that, Ms. Bal, what would you say that these changes, do you think that these changes are
I don't think so. So if you look at it, what
Right.
Article 4 talks about, you confirm that there has been a settlement,
Correct.
but you're still not giving evidence there. So that's very different in terms of saying that has there been a settlement? Were you a party to the settlement? Have you been the mediator for the settlement? Is different from saying did the parties discuss this issue?
Right.
Can you corroborate? So we cannot corroborate anything that's said in a mediation.
Right.
But also, if you look at how things are happening in other jurisdictions,
Right.
because confidentiality is paramount, but
Right.
confidentiality is during the mediation process. Now, what will come out, and this is going to be, as a lawyer, this is why we'll look at, jurisprudence coming out.
Correct.
What is said when in mediation? So when does mediation start? When does it end?
Correct.
What is the pre-mediation? How much do the parties disclose? Now, if you come, and the challenges where I'll talk about, if you look at where the Indian law also says that, suppose there has been a mediation in which a party admits to committing a crime. A party admits, for example, a POCSO crime on child sexual abuse. Now there, do you breach the confidentiality and disclose it? Are you obligated to do that? How do you treat it? How do you then view confidentiality under the mediation process vis-a-vis the obligation disclosed under law? I think those elements will come in gradually, and we'll see more jurisprudence coming on that. But those are challenges that we see. But I don't see the Singapore Convention and the requirement of holding it and mediators not coming to give evidence in conflict at all.
Right. Thank you, Ms. Bal. I mean, I think we have questions coming in from the participants, which is great. Although we would encourage more to come in. But it's my responsibility to bring that question to the panelists. So I would like to bring Mr. Mirza into the discussion. Mr. Mirza, we have a discussion from a question from the participant. And what she seeks to know is that we see that courts have a separate mediation cell, which is generally used for matrimonial and compoundable offenses. But we don't have a law dealing with mediations as such. How far is it reliable or then authentic due to the lack of uniform legislation, in your opinion?
Thank you for that question. Firstly, Anubhav, you use the term mediation cell. So a lot of judges in our court actually mind using the word cell for it. It's called mediation center because cell is more towards going to a jail or something. So mediation center, see what I understand is lack of a statute or lack of a law in that field. Of course, there is a void, and that's where the question comes from. And what is the seriousness or what is the implication ultimately of a mediation being sent from a court to a center or to a mediation center? So it all depends, and as all the panelists are rightly pointing out, in mediation will involve a lot of participation from every angle. So the parties have to be involved completely. The center or the mediator who's been appointed by a center has to be involved completely. Shravan was pointing out that mediation adds on an additional step or one more tier into the dispute resolution process. I would say that one should always, a party, or I am usually representing parties, but if I am a party, I should only look at mediation from the aspect of killing the litigation then and there and not going further with either arbitration or going back to the court. I also would say that when a party is referred from a court to mediation, there attains a kind of a responsibility of the party also towards the court. So as we see, a court usually sees the judges read the file and understand that there is a scope for mediation, and then they send the matter for mediation. So there is a level of seriousness involved in terms of the parties also. And they tend to do something to resolve it and go back to the court, not simply saying that we could not resolve it. There is some amount of confidentiality, at least so far as I talk about Samadhan, which is the Delhi High Court Mediation Center. Of course, when a party is referred, if the mediation goes on for months or years, maybe. I am a participating in a mediation which is going on for 2 years now. So the report that comes in does not disclose any discussion. The mediator is not supposed to talk about it. The report that comes in, I'll tell you what exactly it says is could not be resolved. That's the only report that goes back to the court. So no attribution of any liability of who dragged the process or who did not participate properly. So that's the interplay that we do between mediation and court referred mediation. So that's I think how it plays out in practical world so far as we are concerned. And as I said, that it is once it is referred through a court, there is some amount of seriousness there. But yes, of course, getting this act in place will, of course, increase the responsibility, increase the responsibility of everybody in the system to have more seriousness towards this process. I think, Anubhav, you are on mute.
Thank you, Mr. 𝗵𝗲. I think that throws light on the question, and I hope the person who asked the question, your question has been answered. Going a bit away from that conversation, the trajectory that we were trying to follow in terms of the future of, let's say, mediation in light of the Singapore Convention of Mediation. As you would see in the draft bill, okay, and I would like to take an academic perspective on this, so I will invite Dr. Sharma to maybe throw some light on this. Section 6, subclause 1 of the same makes mediation, like pre-litigation mediation, mandatory. And it uses the word shall, irrespective of the existence of any mediation agreement. Now, my mind takes me towards the concept that is it a divergence from the process that mediation is a voluntary process per se? Dr. Sharma, if you could kindly shed some light on this.
So it's always very difficult to comment on the Indian law, and particularly the way it is drafted. It's very interesting. Like, I had an opportunity to give comments before it came out. So we had some discussion, but the text of that and this text is a little different, I must say. But let's not go on over there. What is interesting to see that why this pre-litigation mediation came is from the international practice. And it is now a general view that all civil matters must go to mediation first. And that's why the idea came. And that's how it was included, that if we just leave it to the parties on a kind of a voluntariness, then they will not go. And therefore they say that, okay, you have a right to go to court, that's we understand. But from the court side, you must show that you have tried mediation. So that's the way, like, the pre-litigation has been done. And that's why I say whether you have a mediation agreement or not, it doesn't matter. It means it's now compulsory that you should go. Is it something different and something new? No. In other countries, it's very normal. Like in Australia, is understood. You file a case, immediately you will be sent out. Even from the filing stage, you will be sent out. So it is a mechanism that not to overload the court system. That's why it has been agreed. If you look at in future and in the long term, at this moment, people are a little jittery about it. But if you see the long term, this is a good approach. You should have that. And so far as the lawyers are concerned, their job or their money will not be in a problem. Those who want to practice as a mediation, even they don't have to worry about whether they will have a cases or not. And I can tell you that very soon, like, from the other experience, like I can just give you an example of Australia. My colleagues here, when they were doing before the pandemic, they were all saying that we are not getting enough cases. We are not getting enough cases. And suddenly the government tweaked the rules and said that everything will go to mediation. Now these mediators, those who are complaining about no cases, now they are saying that we are working too much. We want to have a break. We need a mental, break from the cases. And they are now rejecting the cases. So this is a mechanism that we have to adopt. And outside India, Indians are considered very litigious, and that's why this kind of an approach, I think the Indian government is using that part. And if you can permit me, I just want to clarify two things which earlier happened in discussion. One, in relation to Australia has signed it or not. Australia has signed it. Just in September, they signed this one.
Okay.
After our lobbying for 1 year, finally they did it. They missed out. This is another thing to understand in the new convention when we discuss, and you guys have to be careful. If your Indian delegation is taking part in any UNCITRAL or any international rulemaking, make sure that this should be their responsibility to come back to India and talk to their stakeholders and say that what was the discussion and what should be the new proposal. If you do not engage, you will be left out. That's what it happened. Australia has signed. Article 1 is not restrictive. Actually, right from the beginning, the only demand was that we need a convention for international mediation. We don't need for the domestic one. Convention is not needed. And actually in UNCITRAL, in the initial draft, they give the title instrument. They never said the word model law or convention. So they drafted, the first one was like just an instrument, which could be modified as a model law or as a convention. Later on, the famous New York session, when everybody agrees that it should be convention, then the wordings were changed and made convention. While the initial version is included in Article 14 expanded version of UNCITRAL Model Law 2000, and that was drafted for the purpose of countries to adopt in the domestic situation. So India could have adopted, but the mediation law, the draft bill doesn't show that kind of a thing. So that is your thing. Article 4. Actually, the reason for Article 4 is not to say that whether the agreement as such is acceptable or recognized by the court, functional recognition. The idea was that whether it has occurred or whether it has come out after mediation or not. So an evidence of mediation was needed, and for that purpose, it was considered that any evidence we can use it. And the one proposal was that that even the client, if they have paid the money to the mediator, and if they have invoice, that should be good enough for the court to accept that there was a mediation and this settlement agreement has come out of the mediation. Now, why this discussion came? Because it's the same thing which in India you have seen, the fraud, corruption and all those things. There was a very interesting discussion. It came that what if somebody is doing a money laundering by just saying that, oh, I'm sorry, we are party to the mediation. I have lost this mediation, and in that return, I have to pay $1 million to this party, and therefore I'm transferring this money to them. So how a court can be assured or sure about that there was really a mediation, good faith mediation, not a sham mediation. So for that purpose, the court has been given the ultimate. The court may inquire or order them to give any other evidence to prove that there was a mediation. So just to plug that area is there, but I don't know whether in practice we can plug it or not. So those were the things which I wanted to add it. But the future of mediation so far, I think we should be hopeful and positive about that. It should go forward and it will be very bright. If you compare with China, the amount of mediation you will get it, all the lawyers will be very tired of doing the mediation, I can tell you that.
Thank you, Dr. Sharma. That indeed throws a lot of light on whatever we've discussed so far, and right from your experience of deliberating on these legislations, and also from your personal experience. I think Mrs. Bal would like to shed some light on that. I mean, if you would.
So the thing is, pre-litigation mandatory, it's not the first time that we're looking at it in the Mediation Bill. The Commercial Courts Act itself came about in 2015 saying that, we'll have pre-litigation mandatory, Section 12A made it there.
12A,
then when the rules came out, they made it sort of diluted the intention of what was there in Section 12 and said either party can ask for mediation. And recently Madras High Court has also said that, it's not mandatory. Now, while we have mediation in the bill that says it is mandatory, I think we still haven't seen the rules. Now, would we see what's happened with the Commercial Courts Act and then it heading there? That's a challenge. But, when you look at voluntariness of, whether you're looking at an opt-in or an opt-out method, and when you talk about pre-litigation mandatory mediation, you're looking at opt-out, that you go sit for at least one hearing, understand what mediation is about, and then you can choose to continue. It still doesn't take it that you have to sit through 6 sittings, you have to have a mediation settlement. Nobody's saying that you have to do that. But you need to attend that one session and say, I want to proceed or I don't want to proceed. And that is left to the parties to decide. But the thing is that because, again, parties are not aware, they don't understand, And the idea again, why they talk about an opt-out is that if you have a good mediator sitting there, the chances of the mediator convincing the parties that, you don't lose anything by participating in this process. Give it a shot, see for a couple of sessions and see where it goes. If you guys walk out with a settlement, it's good for you. If not, you're already back in court. You're not really, there's nothing for you to really lose by participating in this process. And if the parties are convinced about it, they continue. If the parties are not convinced, they say, sorry, not for us. So it still doesn't take away the voluntary nature of the process itself.
Correct. Thank you, Ms. Bal. In fact, I was reading a report of ADR such. It's a body out of the UK, and what they said that humans in general are confrontational in nature, and anything to bring them to the table is considered adversarial. So, as an anecdote or as a joke, what they recommended was before a mediation procedure, which should be imposed on them, a session with a psychologist should be implemented first for them to understand what would entail after that. For them to come to at least some level playing out. Maybe that would be a good turnaround and would be a good advent of the process of mediation in India. However, we would like to take the discussion further, and I would like to bring Shravan into the discussion. Shravan, so it is my understanding that mediator and inductor quality poses one of the biggest challenges to mediation as we speak. Well-trained media can positively affect the system. However, that seems to be a concern. Okay, do you think be standards or standard set to essentially demarcate what that they should have minimum of 10 years practice in the bar, 40 hours training, and a minimum annual income which should be set to essentially make sure that the whole process of mediation and mediators that come about are standardized, and what we are looking from the process is something that we get out of the process.
Sarkar, it's a very interesting question, and I would say there is no. My response would probably be not considered as an ideal one, because as I've already expressed my mind, I strongly believe in the independence or the autonomy, the party autonomy that is involved in the process of ADR. So if I have a dispute with one Mr. X, and in the substance of a trade dispute, and I would want a particular person, probably he is somebody that I and Mr. X do know each other. We would want him, and there is a meeting of minds between me and Mr. X to appoint that person as a mediator. And Mr. X does not really have the credentials of a qualified mediator, or rather he is not accredited by any institution. Now, this should not in any way take away the party autonomy that is the core of this entire ADR process, the arbitration and the mediation. If you see, even in arbitration, although it is one of the most codified things in the ADR regime, still anybody can be an arbitrator is the norm. There is absolutely no criteria unless and until it is specified under the arbitration agreement between the parties. Therefore, once you talk about the qualifications and the credentials of the mediator to be taken into consideration while parties go for mediation, this is another added step of restriction per se that is being imposed upon the party autonomy. Now, having said that, there is a just slight different view for this answer also from the institutional perspective, because once the ADR clause, now we have to come up with, now we are not in the regime of arbitration, rather we have to speak about a hybrid clause, which also, so that's what we call it, 𝗬𝗵𝗲, or so on and so forth, by the institutions, where there is an arbitration as well as a mediation procedure imbibed into the arbitration and into the ADR clause, where if the parties intend to go for mediation as the first recourse or the first step towards resolving the dispute, they have an arbitration clause, or rather I would say an ADR clause, where it says that this shall be administered by an institution. And now the institutions such as ourselves, and we keep a panel which is just nothing but a ready reckoner just want to go back to one particular place and then pick a person where we do a conflict check and see that, both the parties are not related and there is absolutely, the green list, orange list, and the red list are not being ticked off. And then we appoint a mediator to resolve that dispute. Now, here in this case, a criterion probably is being, the credentials of the mediator will be probably taken into consideration for the institutions to maintain a such standard, probably which will be imposed or rather compelled by the purported mediation council that needs to be established in the country, that, you can only empanel persons who have these credentials or these training, background. So certifications and so on and so forth. So it probably is easy for institutions to appoint mediators from their panel and make sure that they maintain a panel of mediators who have the required credentials as prescribed again by the Mediation Council. But we as much as I'm in the industry and I'm a practitioner, and I also have to look at the advantages of institutional arbitrations and institutional mediations now. Now, institutional mediations is definitely much more, helpful to the parties and much more robust because there is a set prescribed rules thereunder. But the ad hoc methods probably would also have to be taken into consideration while dealing with this. And if you really make, certain impositions onto, who can act as a mediator, you are taking away the entire autonomy of the procedure, is what I believe. Now, institutions can do that, but parties, if you want to go for ad hoc, probably will not be able to. Now, it's a completely different question if the state intends to impose only institutional mediations to be valid mediations, and the settlement agreements that have been recorded in an institutional mediation to be, forming under the purview of the convention as well, to be enforceable across the states when there is an international mediation per se. So that's a different aspect altogether. Now, if you're going to do such a step, take such a step by the state where you're going to mandate institutional mediation only upon the users, that's the clients, that's you're entering into the realm of party autonomy and taking that away. So it's a very complex thing. And just to contribute more to that, the pre-litigation aspect of it. See, there is a saying in my from where I come that, you can actually bring a horse to the water, but you just can't force it to, dunk its head into the water and make it drink. So just like that, we have a concept of unresponsive, respondent in arbitration. Like that here, if a party sends out a notice to its opponent and calls for a pre-litigation mediation as mandated now under the Mediation Act, the proposed Mediation Act, there is no response, then how would that unresponsive, conduct of the respondent be considered? Will it suffice that the pre-litigation mediation step had already been concluded and parties can be, it can be taken on record? I mean, just to contribute to what Ekta was saying about the Commercial Codes Act, which also had such a similar provision, but the rules diluted the entire process. So this is all, it's just, test and experience. You just have to actually employ it and then face the difficulties. But as practitioners, we should actually oppose such an idea, or rather we should actually come up with a suggestion which is much more robust, and those procedures have to be incorporated into it. And just another quick minute I would take that the entire Mediation Act, although, and it does talk about in its preamble that it is to promote institutional mediation, but I rather just don't find any mention about the autonomy that will be given to the institutions as well in having their own rules to administer the mediations that they would be administering and conducting. So again, it's all test and experience kind of a situation right now. We are just testing water. I mean, absolutely. I'm not making any adverse comments against the persons who were behind the bill, but I was also asked to participate in a convention where even before the bill was being introduced, the draft was just circulated among some practitioners on a chapter-wise basis, and we were actually rendering our comments to it. And I was also opposed to the idea that there is no need for codified law as such for the mediation. But now my perspective has definitely changed. And I think to bring about more importance, as to the validity of a mediation, especially commercial mediation. We need a codified law for sure, but one has to really look into the provisions and make sure that there's a contribution made by the practitioners to the state, so that they are incorporated before it gets passed as is. I think it would be a grave mistake on the part of the state if they really pass it as is. It's going to really call for a lot of discussion and a lot of debates, and it's only going to add another step towards enforcing those things, and people will be going to the courts to do that. Again, that's not what is the intended purpose of the Mediation Act, is what I believe.
Thank you so much. And I mean, that was indeed insightful, and of course, a different perspective altogether. But I think there might be another school of thought in relation to this. And if any of the panelists would want to weigh in on this, I mean, that would be. I think Apurva, please.
So my first comment was regarding the previous topic of discussion regarding the mandating of mediation, like making it compulsory for parties to enter into. Now, my perspective comes from investor-state dispute, and one may question that whether Singapore Convention actually applies to investor-state disputes or not. So now, one line of thought is that because Article 1 of the convention limits it to commercial disputes, and but the word commercial is not defined in the convention itself. Now, if we read the preparatory work along with the model law, and we can argue that the investor-state disputes would be covered, and it is ideal that it should be covered because they form a large part of like arbitration disputes that happen, and mediation would offer a good alternative to that. Now, if we see mandating of mediation, it has also been done in BITs around the world. It's not a very common practice, but at least one of the parties, the state, may have consented to a period of compulsory mediation or conciliation. But a lot of time, the investors may have not given direct consent that they want to first go for mediation and then they will go for arbitration. So this is an anomaly that is also found in international agreements per se, where at least one party is mandated to enter into mediation, where they may not have the mens rea to actually reach a conclusion through mediation. But I think it makes for an interesting case. One cannot say that whether it's superior to just having a mediation period in between or having a choice of mediation before arbitration, but there it is. And the second thing is that I would like to agree with Mr. Shravan that this extreme formalization of mediation is completely unnecessary. It defeats the purpose of mediation, because the beauty of mediation is that it allows for a level of creativity, a level of flexibility that arbitration and definitely litigation lacks. So, like, if we see from a common man's perspective, litigation is very expensive. It's very tedious process. It's a nightmarish process for a lot of them, and especially for small businesses or more of family-owned businesses. Entering into a litigation is very tedious. Arbitration is somewhat better, but not exactly the best solution out there. So a lot of them, even today, they won't call it by mediation, but there is involvement of other parties. So, for example, if there are guilds of goldsmiths that would be there, for example, in Rajasthan, they would have someone from the community, from someone who is a jewelry business owner, only coming in and mediating the disputes. Now, this is a very informalized process, and the settlement, whatever settlement is reached, it may not be completely enforceable. So that could be one of the negative points that would be there. But if something like if the mediation bill takes care of it and actually grants recognition, proper enforcement provision for this sort of process, also dispute settlement process, also we can really see a lot of quick resolution of disputes, and bring in a regime that is there, a dispute resolution process that exists in informal way outside where lawyers work. actually being recognized and being mainstreamed?
Right. Thank you so much, Apurva. I mean, think with that perspective, I think Pranav has also wants to say something. Pranav, please unmute yourself, and if you can shed some light on this.
Yeah, thank you, Anubhav. Just a comment to supplement what Shravan and Apurva was saying.
Right.
That from the quality of mediators, right? If you look at I'd mentioned the SIC-ARBMID protocol, SIC-SIMC protocol, so which is where you see parties first coming to arbitration, and then the matters refer to the Singapore International Mediation Center, which has its own panel of mediators, and you have the mediation center there choosing the quality of mediators that it has, which is why it is a very popular choice amongst users simply because of the high rates of settlement, because of the kind of mediators that are empaneled over there. And then that sort of ensures that the whole purpose of mediation is not lost. It doesn't become another tick box before arbitration or litigation. So it's very important, while you respect party autonomy and ensure that the flexibility in mediation is provided. Parties will probably disagree on the time of the day once a dispute starts. So it's sort of important to ensure that whoever's the mediator knows how to handle and ensure that the party's bargain is actually given the efficiency that they'd agreed upon.
Right. Thank you, Pranav. I think that's a different perspective. But in relation to, I mean, standardizing the mediators per se, which has also been a comment against. I would like to take Mrs. Laura's opinion on this, and maybe throw some light in what is the practice which is prevalent outside in terms of standardization of mediators, if any at all.
Yeah, I just wanted to point out regarding the discussion that my colleagues were having about the essence and the nature of mediation being an informal process. I completely agree. It's actually one of the beauties of mediation as opposed to arbitration, which has become more and more formal. I would like just to put out there that sometimes we internally, in my team, we have had discussion whether the informal nature of mediation is actually a contributing factor for not being as successful dispute resolution mechanisms as arbitration. And I suppose this comes down to how educated and sophisticated the parties are, how familiar are with the mediation process. We cannot, I think it's not, it's easy to forget, but we shouldn't forget that actually the approach towards mediation is very, very strictly related to the culture of the parties, how used they are to having open discussions, and with a view to settle. Because many times a mediation ends up being a dispute of a dispute, and they end up in arbitration. As to the standard of mediators, I agree with what my colleagues have said. In a way, here in the UAE, we do have panel of mediators. In my experience, the mediators that we usually appoint have previous experience as mediators. That doesn't necessarily mean that they are certified mediators. That can be on one side a little bit dangerous because you don't really know how they are going to approach the mediation. However, in my view, it gives me more confidence to appoint someone with experience as a mediator than someone who is a certified mediator but does not have the experience. I think in relation to this about the standards of mediators, I think it's important to bring up Article 5 of the Singapore Convention. Here in the UAE, we see this as a potential pitfall and a potentially problematic provision because it is not defined what is the standard that a mediator should have. and this is in light of enforceability of mediation order. I think, as you all will agree, it's actually an objective standard. However, the Singapore Convention wording is very vague in that respect, so I'm not sure what we can expect, because it's ultimately going to be interpreted by the courts.
Right. I think Ekta has a question to you. I mean, Ekta is posing a question, and if anybody would take that.
So as a mediator, can you really have a standard for a mediator? And if you say this is a standard for a mediator, what would it be? Because eventually, and Shravan will agree with me, because mediate, and anybody who's actually been in mediation is actually a skill that you bring across. It's about how you communicate. There's several soft skills. It's about how do you understand underlying issues? How do you get the parties to talk? So if you say that do a 40-hour training, do this, do XYZ, you could pass the academic requirements and clear a course. But it does not necessarily mean that you, in a live situation, that you will be an effective mediator. So I think it's the market who will actually decide as to where a mediator's practice will go and how the market feels. And market will decide, because eventually, if you're a good mediator, the parties who appointed you will be happy and they will refer you along on the way. But having said that, once you have but yes, it is important that a mediator understands what mediation is about. It doesn't mean that they sit and, adjudicate on a matter. They don't sit and, give suggestions and things. Of course, then there's of course a view about whether are you a facilitative mediator, are you evaluative? Now that's an entire discussion in itself, and I don't think we should probably get into it because it gets too technical. But for a mediator I think it's important that a mediator understands what mediation is, understands the basics of in terms of, the broad contours of neutrality, confidentiality, etc., and about the legality of how he or she can set out an enforceable agreement that the parties will enter. Beyond that, everything just comes with experience, with the mediator's inherent sense. In fact, there is a view that says, do you really need to have a training for mediators? There is a bunch of people who actually say that can you really say that if you do this, you will be a good mediator? And I agree with that. You can't say that I've done a 40 hours program and therefore I'm a good mediator. It doesn't work that way. But I think, yes, but as an institution, like if Shravan is, running an institution and there'll be others, or 𝗓𝗵𝗲, if you're saying that, yes, I will recommend this person, you need to have certain yardsticks that you can show that, this person at least understands this, has some kind of credentials, so that you can, because you are then also vouching for that person. And that, I think, institution to institution, they need to sort of say that these are the basic standards that my mediators need to have. The rest is all, where they take. But the risk also runs that, and this is something that we see today, that, a lot of mediators who are appointed are actually retired judges who have not done a mediation training, but the parties prefer them as mediators. And it's, I think, called a judicial hangover, that, wherever I have a dispute, I will see a judge either as an arbitrator or a judge as a mediator. So that's something that we need to also see how that goes.
While I absolutely understand the discussion and where it has gone in relation to the requirement of flexibility and fluidity in the mediation process, but I mean, the number that was posed in front of the panelists for minimum requirement of 40 might not be per se a prerequisite or an academic requirement, but the essential understanding is that whether there was a requirement for a basic, the modes or the mindset that a mediator should have, or a minimum age,
But actually, if you look at the mediation bill also, correct, the mediation bill says a mediator includes a person who has done a 40-hour. It doesn't say that a mediator can only be somebody who's done a 40-hour.
Correct.
And if you go internationally, they see that, because at the end of the day, the settlement agreement can come in any form. You could have great mediation advocates sitting with the parties, and they will facilitate a great agreement irrespective of who's a mediator. That's also possible. And and it's while we talk about you having a good mediator, it's very important to have good mediation counsel with parties as well, who can actually facilitate the mediation discussion with the parties, who can let the parties understand their interests and move along the process. Because you might have a great mediator, but if the parties say, I don't want to listen to you and I'm only stuck with my principles, there's no movement in terms of conversation. So you need to have very good mediation counsel as well. So eventually, and if you look at it, as long as it meets the requirement of a mediated settlement as per local domestic laws as well. It is not thrown out of the window saying it's not enforceable.
Right.
Now, whether the mediator has no experience or has done a 40 hours training from an MCPC or from SIMC or from ADR, ODR, that I think will become a moot point.
Right.
Eventuality is going to be, does the mediated settlement agreement meet the requirements of enforceability as per the Singapore Convention, read in line with the local laws? And that's something we see even for arbitration. That's what it is. You know, it's about, it's not really about whether the arbitrator has done an arbitration training. You know, it's about the fact does that arbitration award comply with the New York requirements of the New York Convention? Is it an enforceable arbitrable award under the New York Convention? And then you take it down to the local laws and saying that is it enforceable under the local laws also for the grounds for enforceability set out in that local law?
Correct.
And I think we'll see the same thing happening with mediation as well.
Correct.
And I think Gsouhar also can add to that because he would have seen the entire, the cycle of how an arbitration award when it comes to either enforceability or challenge. I don't think that the fact that an arbitrator has done an arbitration training really comes up.
No, absolutely agree with that. Yeah, go on.
Yeah, I really support Ekta and whatever she's saying, because see, where do we come from? Where does this concept of mediation come from? Is from panchayats. If you go to panchayat few years back, when we were not there, they were not trained mediators or trained people who would have training in resolving disputes, but they used to exist and they used to resolve disputes. Of course, I'm not comparing or not saying that that's the same concept here. But a mediator should be a dynamic person who understands human values also, who is taking what from the process and all. So as Ekta rightly pointed out, even arbitrator, you can't train an arbitrator. An arbitrator has to be a person who understands your business, the dispute, etc. So you cannot train somebody to be a mediator or an arbitrator. So that mentality, I would say, is of course a bit strict so far as when we talk about getting into a legislation or getting a statute to deal with this area, and those restrictions should not be there. They should actually reconsider and say that like usage of the term including. So that's fine, but it should not be excluding somebody.
Right.
My uncle or my friend can be a mediator in a dispute I'm having. So and they can be the best people to resolve it, and not a person who has done 40 hours of training into mediation. So I think that's how it is. And there is a very good question. If I was just checking the question and answer box, and it was a question for Dr. Sharma, that suppose I have done mediation through traditional method like happened in a family settlement. Can I claim that I have already tried mediation and seek exemption? The answer should be yes, according to me. It should be yes. It is not yes, of course, but it should be yes. That yes, I tried mediation through my family means or my friends, and that should be acceptable to the court. But unfortunately, it is not. If I'm not wrong. So that's the approach one should see, and we should not now again go to that arbitration regime that yes, we will appoint an arbitrator, we will have some sessions, we'll go to CAC or we'll go to LCIA, and then we will appoint somebody. And so we have to get past that. And again, rightly pointed out a very good thing that retired judges being arbitrators is what is the norm. I rather 100% of my matters has that. I don't have one matter where there is not there is a person with any other qualifications. So yes, of course, we are coming from that hangover. We have to really evolve. We have to see how our matters get resolved in a more efficient manner and a more comfortable manner. I would say comfort is more important rather than making it more and more institutional or more and more formal for that. Of course, seriousness comes in when it becomes more formal, and we are seeing a change in the overall mentality of people towards it. But yes, putting a regime in a manner that yes, it's a mandate would of course not take away the essence of it being a very a more human-centric approach towards resolution of dispute is what my view would be.
No, that's fairly put out, but and I absolutely appreciate the whole fluidity, like I said, of the process of mediation and it being a very organic process rather than a process which is set within its bounds. Having said that, I mean, in my personal experience, I have had clients who've come up to me and who've said that the whole experience that they have had in terms of mediation has been extremely lackluster in terms of the approach taken by the mediator, right? And so what they say is that they were not at all interested in the process. They didn't show up at times. When they did show up, they did not know what to do. Okay, maybe it is their inadequacy that we are talking about. So I mean, how do we bridge the gap between the good experiences and the bad experiences, therefore making it a much more uniform process for everybody. And that, in my opinion, that should be the outcome. So if Ekta, you would want to take that.
So I think a lot of the experiences depend on, one is the mediator and how you work with the mediator.
Exactly.
And also how the involved the parties are. See, sometimes what happens is that parties get into mediation not understanding the process. They don't understand that for a mediation, they also need to work. They're expecting, the mediators to say, okay, fine, this is how the dispute is, and these are the kind of settlement terms you can get into. Now your dispute is settled. So sometimes they don't want to work on figuring out what is, because they are looking at positions. They don't move down to their real interest. They don't have counsel who can counsel them also as part of the process. But if you look at, say, those are some laws. But if you look at, and I think Gauhar, who actually does work with Samadhan, will also be the experience of people who are in Samadhan will be very different from, say, people who are doing court annex mediation in some other parts of the country as well. If you look at people who go to the Bangalore Mediation Center, their experiences will be very different again, because these court annex mediation centers have evolved to where mediation now has become very professional. So the chances of good experiences will be more than the bad experiences. Having said that, it again depends on the mediator. And I said, so, a lot of the mediators they've all done the MCPC training. You cannot be a mediator in a court annex mediation without an MCPC training. But the two that truly really understand what mediation is. They can be saying, okay, fine, I will do this. But how evolved are they in terms of their own skill sets? Do they really understand and have conversations with parties saying, okay, fine, if it's a commercial dispute, are they willing to talk to the parties and saying, okay, fine, you're telling me there's a breach of the agreement, but isn't this a commercially, settled agreement? A breach happened. Have you tried to understand why did the breach happen? And if he says, no, that guy is being, and then you start, how do you tackle, blame games? Because in mediation, there's always a blame game. How do you deal with that? Now, some of these things are skill sets that don't come with a 40-hour training.
Correct.
Skill sets that evolve. In fact, so there is another view of people that says that when people do a 40-hour training, they should do co-mediation with somebody who's relatively senior, so they sort of get that experience, going ahead.
Correct. Absolutely.
Right? So then, like the experiences you've said that, it's very lackluster, and, the mediator did not challenge us enough to get to participate in the mediation. It's reduced.
Right.
And parties also then, once the parties are made to think and being as a part of the process, some of them don't want to do that.
Correct.
So then, then for them, mediation is not for them probably. Or you need to have a mediator or a counsel who can actually push them in the way they need to be pushed.
Right. Thank you, Ekta. I mean, from your previous note that you in what you mentioned prior to this, I mean, what I've taken up is whether to the presence of a mediator counsel, like a mediator counsel per se with the parties. Now, there are two different views on this that, I mean, and I would want first an academics view. So if Dr. Sharma would first give a short note on this, and then I would like to move to, let's say, Apoorva on this. Okay. What I would essentially want to know is that, there are two views on the fact that, the councils being present on mediation chambers, and councils essentially have a very adversarial approach, and their instincts might kick in and the whole mediation process might get essentially derailed. Okay. Do you think it is a positive in the whole broad scheme of things to have councils present in the mediation process, or do you think not to have councils present while the mediation process goes in?
Again, a very controversial area whether the lawyer should be involved or not. That's the
Treading on very dangerous waters.
Very dangerous water, yes. And my personal experience, I was with one family judge who was doing the mediation, and he gave a very nice settlement. He gave a very nice proposal and other. And while I was talking to him on lunch, suddenly the bar association members came to his chamber, and in one part of India, I will not say where, and they started like they said that they gave him notice that I'm going for a strike again, and we are going to close because you asked the lawyer to get out of the mediation because he was talking to the parties in absence of lawyer. If you look at in general practice, international experience, is there something wrong? I don't think so. But in that context, oh my God, like he was facing the problem, and that's what he said. That he said that Rajesh, look at that. I want to help the parties, but I have to deal with the law, like in a bar association. So this is another thing. So far as a mediation in lawyer, and that's why somebody mentioned about, I think Ekta mentioned about that mediation advocacy. So instead of we have one way to train the mediator, but we also have to train the lawyer to tell them that how mediation works and how they are supposed to behave and how they are supposed to deal with the client in that mediation. Initially, in Hong Kong, I was there for 25 years, and when the Hong Kong came up with the idea that pre-litigation mediation, the lawyers were playing the same thing. Just go to room, come out, say that mediation didn't work, and go. When the court has started imposing heavy cost on them, knowing that they did not do it very well, then they started taking it seriously, and slowly the culture changed, and now they are taking it seriously. Where the mediation is more evolved, like in Australia, we don't see this problem where the lawyer will not try. Actually, they will try very hard for that. And when they do not succeed, then they go. So the whole culture has shifted from the litigious to accepting that the value of mediation or it can work. So far as in international commercial cases, particularly in the Singapore Convention and all, like it was discussed, the international commercial cases will be very complex. And the parties may or may not understand. And in that case, it's good to have a lawyer to really explain the parties that the legal implication if they want to discuss about it. So it was there. And that's why in international mediation, we have two ways of doing the a private session. One with the client, and we can also have with the counsels. So this is also a practice which is coming now, and we use that. So I will not reject it directly that we should take away the lawyer, but at least I will tell them to engage with the lawyer, but we have to also educate the lawyer that, look, this is mediation. Your role here is different than what you will do in the court. You want to show your legal smartness, go and do it in the court. But in the mediation, you have to use that skills. So I think the mediation advocacy will be a very good approach, and particularly for the young lawyers and those who are starting now, they should really be thought about and trained about that. Training part, I agree that there is no requirement for that, but then we should have some kind of a benchmark, some kind of a standard. So at least we can synchronize it. Same like CIR, when they run their arbitration course. It's not that I have to join, but if you join and you say that you are certified arbitrator or you are FCIR from arbitration, then one thing definitely comes that you know how to draft your award. At least you know the basics of it. Even the judges, they fail that courses many times. We have seen that. So this is just a part of the training, a basic idea about it. So you will not commit those silly mistakes. So at least you manage. But with experience, there's no counter to experience. Like knowledge is one part, experience is another part. That's definitely is there. But it's there. And I suggest that why 40 hours? I'm saying that it should be 50 hours. 40 hours was the rule when actually it came from Canada, I mean, basically in Australia. 40 hours rule was that when we were having a general mediation. Now we have a Singapore Convention. We have to teach, we have to train the parties and lawyers and the mediator about this convention. So at least you have to give 10 hours. Now the mediation settlement agreement will be internationally scrutinized. So the mediator has to know that what should be the drafting technique. Though it was agreed that mediator may or may not draft, is the counsel who will draft in this situation. So mediation advocacy will be the key to change the mindset. Thank you. You are on mute.
No, these skills are not up to the mark. I did not see your raised hand. So if you could kindly weigh in, Apurva.
So one thing that I would like to say is that regarding qualification for mediation, mandating it by an institution is completely different thing from the government mandating something as a qualification for mediation. Now, I understand that why any institution would like to have certain criteria, and they would like to encourage certain criteria as in their mediators, so that they can get the best, they can promote best qualities in mediation, and they can have set a standard that every mediator can aspire for. And I think this should be done, and it should be recognized that every center should be given the space to set their own criteria, to set their own qualifications. But if the government does it, then it could really kill the I mean, not kill, if not kill, but severely limit the advantages of mediation that are there. So I think I agree that mediation can be like certain criteria may be necessary for a successful mediation and settlement agreement to happen. and these may take place through training or something. But one problem that I have is with the extreme formalization tendencies that we have, that basically everything, like we should just keep on adding criteria and criteria, not questioning whether this should be necessary, or just because this is a standard practice right now, should this continue as a standard practice in the future also. So this could be one problem. And another is that who will provide these training? Like, do we limit the institution that provide these training? And another thing is that basically the language barrier, and regarding who, like the barrier regarding the profession, the people who can actually become mediators. So regarding language barrier, as I think like Mr. Mirza has also pointed out that there are, like, at panchayat level, when mediation in one form that used to happen, it generally would not take place in English. It would take place in the local language. Now, would we provide that training in local languages also, so we can keep mediation process inclusive? We can make sure that the widest set of people can actually become mediators. And another thing is that do we limit it mostly to lawyers, or make it like very legal? Or do we also try to recognize that, say, for something like say, trucking industry? Now, this is a very informal sector, and it's not very technical, but still, like, there are things that only someone who is in the business would know, or there are n number of businesses that would fit in this criteria. So if someone is in the business and he is there, or he has knowledge of the business, if he wants to become a mediator because he has maybe really great social skills, maybe he is the kind of person who is approached by others to settle disputes when they don't want to go to the court, should he be excluded from being becoming a mediator? Or should we provide accessible tools to him so that he could have a mediation process that is actually resulting in enforceable settlement agreement? So I think these are questions that we could really ponder upon.
Great, Apurva. Thank you so much. I think that's a fresh perspective into things. I think we'll take a couple of end notes from Shravan and Laura, and then Laura, if you could, had raised her hand. So Laura, if you could tell us what you want to say.
Yeah. I just wanted to touch upon one note that Apurva just made. I think it's very on point to raise whether the qualification of the mediator shall be legal or not. My view is that if there are currently mediators without any sort of training and any sort of legal background, qualification, I mean, I don't see why the training should be restricted to those qualified people. I think it actually, in fact, is very beneficial to have mediators who have experience and training on a different industry other than law. But I think ultimately this should be offered and it should be an option to the parties for them to choose what type of background they want their mediator to have. As in arbitration, we have seen a lot of dispute resolution clauses that already include the type of qualification, background, and expertise the arbitrator must have in order to be appointed. I don't see why this couldn't be also an option for the parties. And then I would also like to make a comment about something Dr. 𝗓𝗵𝗲 has said before, and I cannot agree more with the point that lawyers have to be educated in mediation. It is an obligation, or it should be an obligation for us, if we see the potential of settlement through a mediation, should be an obligation for us to offer that option to the parties, because we cannot continue saying parties are not educated in mediation when actually we as lawyers, when the parties come to us, should be the one giving this knowledge for the parties to be able to decide. I think for parties to make an informed decision, the first people who have to be trained in mediation and that could be achieved should be the lawyers. But at the same time, I want to stress that mediation should only be offered to those parties or in those disputes in which there is a real potential to settle through mediation. There are many times that at the very outset, as a lawyer, you see that mediation is not going to be the option. And it's about offering the best option for the parties.
Thank you, Laura. Thank you, Laura. I think, Shravan, you wanted to weigh in on this as well.
Yeah, it's. I think I lost track of which one I wanted to respond to, but anyway, what I just wanted to say was, Mr. Rajesh has really. I think it's a gospel what he said from an academician's point of view and also from a user's point of view. But having agreed to that, I would also say that the education part of it, Laura was also stressing upon it, is absolutely very, very important, and especially for the practitioners from the legal fraternity to the limited extent. I'm not saying only lawyers, but we do come across as institutions people from engineering background, probably who are retired chief engineers in a particular department of a government, or chartered accountants, or architects who have a tremendous experience in executing civil or PPE contracts, public-private enterprise contracts. They do have, and we also have a Society for Construction Law that is established in our country as well, which contribute tremendously to the arbitration arena. So all these practitioners should at least have some sort of a recognition or some sort of a outlook that it is better to be trained rather than just going and just being a mediator. It's absolutely very, very important. Nothing can beat training. Absolutely, I really second with what Mr. Rajesh has said and Miss Laura has just put it out. But precisely for that reason, again, it cannot be mandated. Right, is what I believe. It cannot be really, the user cannot be put into some sort of restrictions and not exercise their autonomy as to who can be the mediator in their particular case. So when such things happen, when the user intends to go for a mediation which is being mediated by people who are not accredited or who do not have the required credentials, the purported credentials as per the government regulations, still they should be able to do so. And in that exact scenarios, the importance of institutional mediation would come out, right? Institutional mediations would actually render a lot of help, invaluable help to these mediators as well as the users to make sure that it is being transgressing not into other areas, but it's being streamlined and it is being conducted in a very proper manner. And the institutions exactly, that is why the institutions are there, even for the arbitration purposes as well as now. Now, once institutional mediation starts taking its own prominence, I think, especially in the scenario of a commercial mediation, the other aspects of mediation, I would say, which is a personal dispute between the parties, because any dispute involving a family dispute cannot be arbitrated, but rather it can surely be mediated, including the domestic aspects of a husband and a wife. But institutional mediations always tend to call themselves as the institutions that are administering commercial mediations. And for these other mediations, such as the domestic issues or the family disputes, are being taken care by the mediation centers that are annexed to the courts itself. So even those mediators who are handling these kind of disputes in the domestic arena should be properly trained so that you're not wasting the valuable time of the users and then they don't lose the trust. Absolutely, as put by Mr. Rajesh, that in Hong Kong, people used to just go enter into a room and then just come out and not really care about what exactly transpires there. But no, here it has to be formulated in such a manner that these mediators who are annexed to the courts, who handle domestic disputes and family disputes, have to be trained properly, that they are actually giving the best out of this entire system. And the commercial mediations, once they are being handled by the institutions, we have our own set of rules, as I've stated. We will be there, these institutions will be there to enhance the entire experience of the user, right? How to go about this, how to formalize this into a particular manner, and the seriousness is not lost, but on the other hand, the autonomy is not being lost. So there is a bit of a balance here that institutions can really, bring about to this entire system. And unfortunately, I mean, I also see a question in the entire Q&A that one Mr. 𝗬𝗓𝗂 𝗖𝗶𝗂𝗂 says that you mentioned about HAC rules. Can you please throw some light on this applicability? Because we are aware of the Delhi rules. Do states have different rules? So now framing of rules by the institutions to administer mediations or arbitrations is also another part of the entire autonomy that is given. So how a particular arbitration or a particular mediation will be administered and taken to a logical end of an award or a settlement will be governed by a set of rules, like something which will govern the conduct of this entire process. So people are unaware as to the fact that, the moment you call something rules, they tend to apply, oh, is this state mandated? Is this something that has been promulgated by the state as an act or a rules annexed to an act? Or is this something that has been done by the court itself, the high court of a particular state? So these ideas have to change. Education is completely important. They need to understand that if you go for institutional arbitration or institutional mediation, there are certain set of rules, and you please read the rules which are published publicly in the respective websites or wherever the institutions have them, and understand that, oh, okay, I take step 1, step 2, step 3, step 4, and there is it. I have the award, or there is it. I have the settlement agreement. But this education needs to be important very well. And the other part is the mediation bill that is now introduced doesn't seem, if you look at the Singapore mediation, Singapore Convention on mediation, it probably uses the word institution once or twice in the entire text of that convention. It does not stress more upon, but it is actually deemed to be understood that that's how it has to be conducted. But if you look at the mediation bill that now is purportedly going to be an act in our country, in India, the preamble itself says that this is to propagate and promote the institutional mediation. But rather, I find it quite amusing that, they do not address anywhere as to the autonomy that will be given to the parties. Although they do have a section of ad hoc mediation, but they do not really delve upon it. And when it comes to the institutional part of it, when you're saying it, we want to promote institutional mediation, you need to give them certain liberties, if I may say so. But rather, what they have all done is, under Chapter 7, they want to impose certain conditions of, or rather criteria, to be mandatorily followed by these institutions to allegedly maintain a certain standard. But you are actually completely becoming oblivious of the fact that what you're actually going to, what it's going to cost to these institutions. There should be a balance has to be struck somewhere here, and a lot of introspection is absolutely necessary to make sure that the convention is not being properly implemented in our country in the guise of an act to regulate, if I say so. The regulation is the last thing that we need. What we need in this country for mediation is having a set of guidelines to make sure that it is being legitimately being used by the users as well as the practitioners get some sort of a legitimacy in this. Because one of the most crucial aspects for any mediator, and I would say everybody would agree with me, is the credibility. If there is no credibility, nobody would want you to act as a mediator in their dispute. Now, this credibility will be brought by this legislation, but on the other hand, at what cost is what needs to be seen there. I just wanted to contribute to that also. Thank you.
Hi, panelists. Yeah, so I think Anubhav is a little busy with something, and so I think we can be done with this, the discussion on this theme over here. And thank you to all the panelists for such an engaging discussion, which gave us both academic and practical insights. Having said that, imparting such vast amounts of knowledge may have tired all of you out. And so if you would want, we could take a break here so that you could revitalize yourselves for the discussion on the second theme. And if you all agree, we could reconvene at 1 p.m. sharp to do justice to the second discussion.
So in how many minutes we have to come back?
10 minutes.
10 minutes would be fine. Yeah.
We'll be moving you to
Thank
the
you, everyone.
panelists.
Sorry, my network had just gone off for some time.
Yeah, sure. No problem.
Kushagra, I think somebody wanted to discuss, have a discussion on their thoughts. I don't know if you want to take that up.
Yes, ma'am. So actually, we mentioned it to them that we'll be taking those questions at the end of the session, since we believe the panelists would be a little tired. If the panelists wish, they could stay here and we could open the floor for participants to share their thoughts also.
Because I think there was one person who had actually said that they cannot stay to the
Yes.
end. So
Yes,
Yeah,
so it was
Professor
Mr.
Steve.
Professor Steve Nego. Yes.
yeah, so if you'd like, we can, I mean,
Yes, I'll just unmute him. Professor Steve.
I'm happy to, discuss with anybody who's, again, depends on the other panelists as well. Say.
Hi, good afternoon to all. Greetings from Singapore. Professor Sharma, I think we met a couple of years ago. It's been a while. So anyway, it's been a very interesting. I've been listening for the last 1-2 hours, and I think that the speakers are probably have been quite tired as well. At the same time, I think you have made some very important points. So I thought I'd just like to weigh in on the four points. The first thing first is that the convention, Singapore Convention, and the mediation law and the process of making the mediation law, as we can see in many countries, they are clearly two different matters. So in any consideration, therefore, in us, among others, analyzing the Singapore Convention and at the same time discussing the making of the mediation law, of course, the mediation law would have to be consistent with the Singapore Convention. But as we have seen historically, including the New York Convention, the convention seems to come before the laws. And so anyway, that will be probably for another time's discussion. And point number 2 is that, again, the signing of the convention and the ratifying of the convention are two very distinct matters. The signing of the convention is a very important milestone, a very key step, however, only a baby step. Because most countries in this, it is either a dualist or a monist approach to enacting of law. To that, we have only 8 countries that has ratified. To be correct, to be precise, it's 7 + 1. 7 has ratified, 1 will only come into force sometime next year. So let's just call it 8, with next year coming up very soon. But a bunch of many countries have signed the convention. The signing of the convention, according to international law, is, among others, in layman's term, a commitment to not doing anything contrary to the spirit of the convention. But it is still a very, very long way. In fact, the New York Convention is a work in progress as of now. There are not only, but there are 169 members with new signatories coming on board this year. And that we are talking about the grand old thing, which is the New York Convention 1958. But not only that, it is a work in progress and a long process, like what Ms. Tabbar actually mentioned. I totally agree. We also are cognizant of the fact that right now all the countries in the world are preoccupied with public health issues. So with that, I think we can forgive the fact that not only it is a work in progress, and that will continue to be progress even in situation where there are no pandemic, but because the pandemic has actually set back so many other things else. I mean, imagine there are some countries that some countries that have not even revised or amend the arbitration law after decades. And do we expect them to just overnight to take on the mediation law aspect? So we all agree, I guess we can all agree, and I believe I am in good company to say that this is a work in progress, but we are optimistic about it. And the third point, I think I hear with so much interest, and I'm very glad that, again, I'm in good company with most of the speakers here as regards accreditation. So many valuable points being mentioned here. I, in particular, looking at the spirit of it all, is that I am concerned if mediation becomes the new litigation or the new arbitration. As regards the issue of accreditation, why are we or should we impose a higher burden in mediation and mediator when such burden does not even exist in the case of arbitration? In the case of arbitration, not only party autonomy rules, I like to say that, in fact, one of the speakers, I don't know whether it's Ms. 𝗖𝗲 or Mr. 𝗧𝗵𝗲, was actually saying about, in paraphrase, I say wisdom. You know, to arbitrate, I think we need a lot more wisdom that goes into it. We cannot just overnight become an arbitrator. And of course, my concern is that with the proliferation of certification of mediators, again, who certifies the certifier? That's another thing. But I mean, at this stage of my life, my career, would I spend 2 to 3 lakhs to go and attend a certification of a mediator course to be taught the basics of mediation when it has been second nature for people like myself, Ms. Bal, Mr. Saka, and the rest, right? So we have gone through that, and that we have to put through 40 hours. Why 40, not 45? Why not 45 and a half? Why not 46 and a half hours, right? The argument goes on and on. I think there's certainly more to that. It takes a lot. It's not something that can be textbook based, you know, and so that would be my concern, because I think there must be a limit to it. Basic training is useful, is important, but ultimately we need to understand why we are doing what we are doing, you know. And we do not want certainly to have oversupply of mediators, and that it comes to a stage, whose dispute is it? That we are telling disputants how to do their disputes, how to manage their disputes, and we have taken over it. I think that's one concern. Although I'm aware very quickly, I know I'll just come to an end very quickly, that for instance, if we turn to the Singapore Convention, in the Singapore Convention, the only point that might raise this question about certifying mediators or accredited mediators, which, by the way, there are no mention of accredited mediators in the entire Singapore Convention. In the Singapore Convention and Article 5.1e. Article 5.1e merely talks about professional standards. So it says here, a serious breach by the mediator of standards applicable to the mediator or the mediation. I know the word standards, some would like to split hairs and say that standards could mean professional standards, as in qualification, not necessary. But rather, if we read the preceding lines, it talks about in the absence of these standards, and that without which the parties will not have entered into the settlement agreement. So what does it mean? So whether the mediator has a PhD in mediation or 140 hours of training in mediation, the fact is, if the mediators turn rogue, it can turn rogue, right? And that the mediators, and this is largely to protect mediation from being abused, from and from being used for its unintended purposes, among others for ill purposes, corruption and so forth. And that corruption and whatever, I mean, that's another day's discussion, is not eradicated by way of having 10 PhDs in mediation either, you know. And so that would be my point. And also, interestingly, in this entire Singapore Convention, how many times is the word institution being mentioned? The answer is only once. Only once. Only once it is mentioned in that an attestation by the institution that administered the mediation, without which, in its absence, also any other evidence acceptable to the competent authority. This is in relation to Article 4.1b, in terms of the evidence that the settlement agreement resulted from mediation. So here we can see, we are glad, and I'm so glad that the Singapore Convention, or like any United Nations Convention, regardless of Singapore, I mean, Singapore is a label, but any United Nations Convention, it is intended to be used, to be adaptable, and to be flexible, and to be broad. And therefore, that also brings me to a sub-point under the third point that I mentioned, is that sometimes it baffles me how this idea about certified mediator, becomes such a hot topic, taking center stage in this whole discussion about enactment of any mediation law. Because, put simply, if the mediator is not certified by any authority, but a 60-year-old leader of the industry, and everyone respected her or him, and that he or she has not received any mediation certification, does it mean that the settlement agreement arising from this mediation quote unquote, using the terms of arbitration, will be set aside or refuse enforcement simply because the mediator is not court certified, unquote. Obviously not in the Singapore Mediation Convention. And finally, of course, the final point is that mediation in the Mediation Convention applies to international mediation and not domestic. And therefore, if in domestic level that there are certain provisions or certain requirements that has been imposed by the local state courts and the jurisdiction, that is perfectly fine. For example, in the Singapore Mediation Act of 2017, there is a mention that if two parties have entered into a settlement, mediation settlement, and that would like the court to endorse the mediation settlement as if it is an order from the court requires this mediation to be conducted through an institution. So, and the institution will then, of course, require the mediator to be certified, to be accredited, and so forth. Then I suppose it's fine, because it is for a local level, local purposes. Each to its own. I can't necessarily say that I'm against it, but I think it serves its purpose. But if we are looking at international mediation, a much more broader perspective, and I think it is right that the United Nations Convention therefore wants to promote mediation. The purpose of the mediation is to help businesses to grow, and therefore the spirit is such that it is a broad spirit for us to be able to absorb and embrace. So with that, I have nothing else. I better stop talking, and I again like to thank the organizer and the speakers for such an excellent session, and I look forward to the second part of today's colloquium. Thank you.
Thank you, Mr. Steve, for your insightful discussion on the issue of the Singapore Convention. And I believe that the panelists have returned to the main session to carry out the discussion on the second theme. And I again pass on to Kabir to lead us. Thank you.
Professor Steve, thank you so much. You've beautifully summarized the discussion that we had. But just two things, one I'd like to say that, when you're talking about the professional standards that we're mentioning, and this is something we're also seeing in the Mediation Bill in India, it's a code of ethics that the mediators need to follow. So I think that is something which is sacrosanct, that you cannot breach your neutrality, confidentiality. So I think those are things that we'll see more of. And the other thing is, while it's a good start to have, but the Singapore Convention is only for international commercial mediation, and it's not for all international mediation. So, as a mediator, when you look at that, you see that there's a huge divide between other forms of international mediation that could happen, which need not be commercial in nature. For example, matrimonial disputes where you have custody issues that could arise between, one parent being in a state A and another parent being in state B, and they enter into a mediation agreement. How do you look at those? Would they not be enforceable, or would you look at it as a contract? So I think that's a challenge but at least from one step at a time, we at least have one international convention to look at some forms of mediation. And I think then after this, I think we can move on to the others.
Thank you, ma'am. And I believe with that, we could conclude the discussions in the first theme. We may have made it more interesting than we thought, and we probably should have allotted a little more time to the theme. But I believe because we have another theme and we need to do justice to it because our panelists have also come to witness discussions on that, we can start with the discussion on the second theme, which revolves around how beneficial it is for ADR institutions to diversify into offering other centralized ADR mechanisms. And so I would like Mr. Sarkar to now take over and moderate the session. Thank you.
So, it was a great discussion in the first one. Sorry, I just lost a bit of connectivity in the end of it, and then it was quite a task getting it back. However, the second discussion, I envisage it to be a bit more free flowing in the sense that there is not much of a pinpointed issues that we can deal with. However, the basic essence of the discussion that I would like to keep it as is, I would like opening statements from everyone, after which we can, get into thematic discussions on the topic. So I would, as like the last time, I would want Dr. Sharma to maybe begin the discussion on this, whether it is beneficial for institutions to diversify into alternate, various offering multiple alternative dispute resolution mechanisms, and then from that we'll take the lead and maybe we'll delve into deeper into the topic.
Okay. Again, when we talk about the ADR, now the definition has changed from alternative to appropriate dispute resolution now. So for institution, it's very easy. I mean, institution can definitely talk about it and discuss about it. And I think that we are still discussing about the stage of mediation. We should think about the mediation, so negotiation. Even the assisted negotiation can go very long way. So institutions should also think about that, how to provide assisted negotiation and discussion on that. It can be done. And for that one, there's another concept which is you can use it in infrastructure like development or dispute or anything. One is called the project mediation. Project mediation is the one when right from the beginning you can appoint an expert who will facilitate the negotiation, then help you to draft an agreement, then the contract will be executed, and this person can supervise the development or the execution of contract. So therefore he or she can pinpoint and tell you that where is the problem and where might dispute arise, and then you can prevent the dispute. So it will help you to prevention side of it. So it's always good to prevent the fire rather than firefight. So it helps. So those kind of discussions are there. So I would say that consider the project mediation and this concept to be developed. And a classic good example is like, I have experiences that Hong Kong airport project, where the railroad and the bridge and the airport, everything was going at one time. And 3 very famous arbitrators were appointed as a supervisor, a kind of a project one. And you'll be very surprised that out of such a big project, none of the case went to court. Only 3 cases went to arbitration, and all other cases were just taken away, just resolved at a very, very early stage. But one agreement was there that doesn't matter what dispute may exist, but the project must go on. And for the countries like India and any developing countries, it's very important that if the contractor has a dispute with the government or any party, the road must be going, construction must go on, the bridge must go on. Like, we cannot stop that, and that will be very detrimental to public. So the project mediation and those kind of things will be very, very important in that one. Another new diversification or the new area which is coming is that in India, I hear this one, but internationally it is also very well used. And you can say for the financial dispute and other restructuring, bankruptcy, insolvency. Now they are saying that in insolvency and bankruptcy situation also, you can use mediation, and that will be very useful. And it has been used. There's an example, Lehman Brothers case and all those. It shows you that, yes, we have used that kind of a thing. So this one will be a very good service. We call it financial dispute resolution or any other, you can use that one. So of course, there's some kind of a legislative backing should be required over there. So that's the one. And another very fast coming area is the ISDS mediation, Internet Investment Investor State Dispute mediation. Under the current UNCITRAL discussion, there is a very big convergence is coming on that one, that even if we don't agree on many other things in the form, but ISDS mediation will come. And for that also the lawyers and our mediators should be ready for that. And the institution can provide specialized services in that one. So all the institution can think about it. So far as India is concerned, I think that ISDS with respect to India is not a possibility, because India has already said that they are not going to apply Singapore Convention in any mediation with the government and state-owned enterprises. So that door is closed at this moment. But it's okay. India is not available to you at this moment, but now in this global world, we can provide services not only in India, but even outside India. So getting ready and prepared for that is not a bad idea, and we should be thinking about it. Thank you very much.
Thank you, Dr. Sharma. I would like to also extend this discussion to Gauhar and take an opening note from him. But on the light that, I'm trying to restrict the opinion view to say that, if an institutional mechanism tries to bring all the ADR mechanisms within its own view, it is often said that it becomes an extremely time-consuming process, okay, thereby defeating the whole purpose of ADR per se as a process, because the parties would essentially be stuck in the various mandates and the rules stipulated by the institution therein, right? So in light of the topic that we're currently discussing, and in keeping in mind this issue, what would your perspective to this be?
Thanks, Anubhav. And I think again, two views, two absolutely distinct views on this. One is the more informal way ADR should be, and the other is that yes, it should be formal. Formality actually brings in a lot of systematic approach to a process, and which is actually helpful when it is a commercial dispute. So if you apply this test to a commercial dispute and you say an institute should be governing a particular ADR mechanism, maybe it's negotiation or arbitration or mediation, for example. So it just gives a more systematic approach to things. The schedule is laid out and there are certain rules that one has to abide to, and it helps in that sense. However, the other view is that why to put something like mediation or negotiation into a formal structure and restrict people? Like we were having a discussion about the bill being considered and act being formulated or a statute being brought with certain rigid rules of qualification, etc. So two separate views. I would go with the first view that yes, it should still be a little, at least mediation should be a little less formal, not putting it into this scheme of institutional mechanism. But yes, I would also not be completely against the idea of putting a commercial dispute or a commercial very complicated matter to resolution through mediation and institute governing it. So it's a mixed, I would say there is a mixed kind of a reaction I would have at least to this. You were saying.
Thank you, Gaurav. I think, thank you so much. I think that is the whole the whole perspective that I also have towards this. That it's a mixed approach. While I see benefits that can come out of it, I also have an apprehension or an apprehensive mind or an approach towards it. Considering that we are all practitioners and we see this on a day-to-day basis, we can see that we can envisage the practicalities that might come out of it, and also see the positives that might come out of it, right? So do you Ekta, do you see any visible negatives that you can possibly see of all the mechanisms intertwined within one institution as such?
So the thing is, having all the mechanisms available with an institution doesn't mean that the parties need to adopt it. Okay, so it's like, if you look at it, mediation is voluntary. So the parties can choose to go under the institution or not. And actually Pranav mentioned this in the earlier thing. So they have a beautiful concept of 𝗵𝗲, that you come into arbitration, you could choose to get into arbitration. It's again choice. You could choose to get into arbitration, and then if it doesn't work, you get back into an arbitration and it moves out like an award. So what happens is, then the parties are determining, and what Pranav didn't mention is that 𝗵𝗲 is not the only method that parties can go to. They also have 𝗵𝗲. They can go for mediation, doesn't work, get into arbitration, and as an institution they work seamlessly. And and I met several people from SIAC and SIMC who actually have the seamless integration of whether you want to do arbitration first, you want to do mediation first, and then depending on the parties, they'll help you navigate the process very seamlessly. And I think that is actually an advantage, especially if you're looking at a dispute strategy. When I know as a counsel for a party that mediation is maybe, and I'm not saying is, maybe an option that I could want to exercise at any point in time, if the institution has a seamless process of shifting from arbitration to mediation, it just makes it more convenient for me to move it internally without getting into the administrative hassles of making another filing, giving up, setting out another brief, dealing with another set of people. I can deal with that institution itself and saying, my parties now want to try mediation. This is the mediation agreement. Please, let me know how to do so. From me as a counsel, and even for my parties, the administrative headaches get sort of reduced. Having said that, Again, because mediation, or arbitration at any point is a choice that the parties can make through agreement, they can always agree to go elsewhere. And the only thing is that, most of the agreements, when you look at how the arbitration agreements or even mediation agreements are defined upfront, there's an entire open-ended thing which is saying that, we'll go to a particular institution like CAC or UNCITRAL or LCIA and saying that these are the institutions we'll use for arbitration. Mediation is slowly creeping in. Having said that, parties can always agree at any point to refer the matter to mediation, whether through an institution or not. But I, as a counsel, find it administratively easier if the same institution offers it. And because the institution doesn't say that you have to use only my impaneled mediators and arbitrators, so I can still have a choice. But from an administration point of view, I know there is only one person I turn to for that entire leg of dispute resolution. I think you're on mute, Anubhav.
Thank you, Ekta. Pranav, I would like to now come to you. I mean, being a part of an institution, you can essentially give us the perspective from the horse's mouth per se. So what I would essentially want to know is basically, in our previous discussion, we unanimously agreed, and which is quite rare considering all of us in the legal fraternity and our lawyers, that the mediation process has to be an organic one, right? Where set rules, boundaries are can be a secondary mode of qualification or medium. The first idea behind the mediation process should be an organic one. However, when a mediation process in the garb of an ADR mechanism is instituted within an institution, there has to be certain standard stipulation which are also brought along with it by the institution. Do you think that the whole quality or essence of mediation per se is diluted by making it a stringent institutional mode or mechanism in your experience?
Thanks, Anubhav. So, I mean, when I read the theme for this session, the first thing that popped out is whether it's beneficial for institutions. I think the bigger question that institutions will ask is it beneficial for users? Because ultimately, what an institution's effectiveness is only what's as fair and efficient as is granted to the users of the institution. So, I mean, again, picking up from the previous theme, where ultimately we discussed quite a bit on how it's important for counsel to be trained in mediation, and it's important for counsel to take that process and kickstart it. So, from an institution's perspective, at least what we've seen is internationally, you have parties from across different jurisdictions coming in, and as an institution, you want to ensure that the parties' agreement to resolve the dispute is given effect to in the manner of that agreement, because more often than not, when it turns into a dispute, especially one that involves parties from jurisdictions where mediation isn't the most popular choice of dispute resolution, you see where local counsel, one of them is trying to undermine the proceedings, the other is trying to take it forward. So as an institution, you need to ensure what the agreement of the parties is. So I don't see mediation being diluted in the sense, because from an institutional perspective, what you're doing is you're strengthening the agreement of the parties. If they've agreed to mediation, if they've, say, agreed to an 𝗬𝗲 protocol, you have set rules where within the framework of which there's enough flexibility granted to parties to take the mediation to its organic end, and with a trained mediator sitting there. So what we would do is we would look at it from a sort of framework view, give the parties enough space to resolve the dispute, but ensure that there are compartments so that it doesn't go off track, so that it doesn't derail the dispute resolution process as a whole. And that's the sort of harmonization that SIAC tries to do with SIMC. SIAC, as you know, looks at the arbitration side of things, and then you have SIMC, which has its own expertise in mediation. So that's how, as a holistic approach, I mean, you have two institutions here setting boundaries and giving parties the flexibility to resolve disputes at the end of the day.
Thanks, Pranav. I think that's, but the thing is that what I would also want to pick your brain on is essentially, do you think that there's any practical issues that you face while transitioning from, let's say, SIMC to SIAC, that in your experience?
But not really with SIMC. It helps that we're all in the same building and we know them quite well. So it's literally the office next door for us. So there's not much of hassle in that sense, and there's a lot of events that SIAC collaborates with SIMC. So we know them as an institution quite well, so in that sense there's no hassle. But I would think that it would depend if the parties say choose another institution to mediate the dispute, then depending on the agreement, right, whether they want the SIAC secretariat to get involved or whether the parties will do it themselves, that's something that would depend on ultimately how the parties decide to transition. Yeah, not so much from a secretariat perspective with respect to SIMC.
Correct. Thank you. And it's just obvious that I would also like to bring Shravan to the conversation, being a part of the Hyderabad Arbitration Center. Shravan, what is your opinion on this? Do you think that is there a imbalance that it causes to the institution as such, or I understand that you think that mediation as such has not emerged as a concept, or to be brought into the mainstream ADR mechanism. However, to be a holistic institution, do you think that, whether it should be bought into the same package together, or if so, what is the, practical irregularities that one might essentially face?
It wouldn't be from the horse's mouth, but we consider ourselves the pony in this regime right now, because we have not really administered any international mediation per se to understand the practical difficulties. But of course, we had an outlook as such. That's why we do have our mediation rules in place. Absolutely, I would really support the idea that there should be institutions should start providing a hybrid system of both the mediation and arbitration under the same umbrella at the same institution. SIAC is, they have the comfort and they also have the luxury of having another institution as such, collaborated with them, or rather in the same building as, Pranav put it. But we have the mediation rules also published, and there is, I would say, an easy transition, right? In terms of when parties intend to first commence the arbitration, and then during the course, as we are all lawyers, we know that once the pleadings are completed, it's a very common scenario that the arbitrator really poses a question that is there a possibility of coming to some sort of a consensus amicably to resolve the dispute before we proceed further to the trial and the arguments. So at that stage, if the parties really intend to, I as a practitioner, as an arbitration lawyer, I have seen so many cases where the parties have said yes, and but they were not institutional arbitration. So in that case, the arbitrator himself seems to put on the robes of a mediator and start speaking to the parties very informally, as if they will not weigh upon the ultimate decision. But I don't think so, that they surely would weigh upon the ultimate decision. If the mediation fails, he will be the arbitrator and it will be an adversarial position, right? So it's not really that effective. But in such scenarios, in practical situations, if the parties intend to go for a mediation option, to exercise a mediation option, a Chinese wall sort of a thing can be created by the institutions, where parallelly arbitration is going on, but there'll just be interregnum period. They will be put on hold for a set period of time. And I'm sure Pranav will have a much more robust experience in that. They might have already done this. That they will just hold it off for a particular time, and the arbitrator fixes a time period during which the parties may exercise this option of mediation by appointing a mediator, which probably would be appointed by the institution itself to save a lot of time. And the mediation would run parallelly in a set period of time, of course, and report back to the arbitrator whether they have arrived at an amicable solution to their problem. And if so, if they did, I mean, there are two scenarios. One, if the mediation fails, obviously the arbitration would continue without any loss of the trust on the arbitrator. And if the mediation is successful, and automatically the mediator would would request parties to submit the terms of their settlement, and he would draw it up as a settlement award or an agreement. And the same would be submitted to the arbitrator in the arbitration. And based on the terms that the parties have arrived at, a consent award would be passed under the domestic law. And of course, even in international, it is possible. And of course, it really attains the status of a civil court decree kind of a situation in our domestic jurisdiction is what I'm speaking of. So yes, it all the more makes a lot of things easy for the parties in complex situations of very complex commercial arbitrations, that the institutions would really render invaluable support to this entire process. And if it is not available, if the parties have gone for arbitration under an institution which only renders arbitration administration, if the parties intend to avail the mediation process, then they will have to really look for a third-party service provider. And it all the more becomes a little bit more complex. So I would say, yes, I think it is, in my view, at least from speaking from not a lawyer's perspective, but rather from an institutional perspective, I would say it is really beneficial for the practitioners and even the user, the clients, to have this entire system into one under the same institution. And I don't see anything wrong with it. And I only see the benefits as of now. I mean, I would probably be, I can stand corrected if somebody puts up a contradictory point of view with that. But yes, I really support it, and I wouldn't have any second thoughts about that. I hope that answers the question.
Yes, it definitely does. And with that, I would want to take a different perspective into a practitioner who's practicing beyond the jurisdiction of India. And maybe, Laura, you can shed some light on what your opinion is on this issue per se.
Sure. So in our experience here in the UAE, in a law firm, we often don't see an institution being referred to when it comes to an agreement on mediation. Usually the mediation takes part as an ad hoc mediation. That being said, I think there are great benefits and advantages about appointing a mediation institution or an institution that offers mediation services as a supervising institution of the mediation itself. That being said, and I think this has been already mentioned by my colleagues, there is a dangerous side of it. That mediation will become a very formal process, undermining the very primary essence and nature of the mediation. In general terms, I can say that institutional arbitrations have the advantage of, and I'm talking now about arbitration because I want to make an example and a comparison to what potentially an institutional mediation could benefit from. In that respect, institutional arbitrations have the benefit of a framework that parties don't have to be worried about whether there will be enough money, for example, to pay the arbitrators, whether party autonomy is being respected, whether if a challenge becomes part of the arbitration process, there will be a resolution to it. So I do see great advantages of having an institutional mediation, yet it is important to keep the parties' autonomy paramount into the process and not making very strict or rigid framework into this.
Thank you, Laura.
I'm not sure.
With another opening, sorry?
No, I was just
Thank you,
asking.
Laura.
Thanks.
No problem. Thank you, Laura. With another opening remark from Apoorva, I would like to move on to Pranav for a question based on what Shravan had mentioned. So, Apoorva, if you can give your opening remark as well.
So, regarding whether the institutions should diversify in terms of ADR mechanisms they are offering, I think it depends on what are the ADR mechanisms that we are thinking of. Like the four most popular ADR mechanisms are arbitration, negotiation, conciliation, and mediation. But this is not the limit of all the ADR mechanisms. There is also mini trial, there is expert determination, there is fact finding, then there is like private judging. So you have a lot of other ADR mechanisms out there in terms of diversity. A lot of this diversity comes from the West only, from USA or other Western countries. But to answer that, whether it makes sense for an institution to diversify, I think yes, because most of the institutions around, the major institutions around the world have started to diversify. They at least offer two ADR mechanisms. WIPO, Arbitration and Mediation Center, for example, offers arbitration, mediation, and then it also offers expert determination. So 3 ADR mechanisms. But does it make sense for each institution to offer all the ADR mechanisms? I think that would be a resounding no, because what ADR mechanisms should be offered by each institution would probably depend on two things. First is basically the legal limitations that it may be having. So an institution in India, it cannot really offer private judging, right? Because Indian legal system does not allow for it. But an institution maybe based in USA, in California, for example, where private judging is allowed, maybe they can offer, or maybe they can offer mini trial and a host of other activities under one roof, so that they can attract a diverse set of clients who are looking for an alternative to litigation. But the other thing that would probably remain a major factor is the kind of clients that an institute is seeking to attract and has already built a reputation upon. So, for example, if an arbitration center, for example, it's like specializing in patent and other IPR disputes, it would make sense for it to offer expert determination or fact finding, or something that allows for a lot of technical issues to be resolved amicably without resorting to one of the more tedious processes. But would it make sense for all the other institutions? Is probably depends on the institution at the end of the day, I think.
Right. Thank you, Apoorva. Now, based on something Shravan said, which is really interesting, is having a Chinese wall, and not to essentially, compensate on the confidentiality standards that should essentially be in each of these processes that are involved, right? Now, Pranav, in terms of the working between the SMC and the SIAC, how is this facet essentially taken into consideration? I'm sorry, if it's a very direct question, but it's very interesting, because there are times, Chinese wall in firms also who work in transactions or corporate transactions might be very difficult to implement as such. So, I'm very intrigued to know about this.
Thanks, Anubhav. I think it helps that SIAC and SIMC are two different institutions. So they have,
Right.
For instance, the secretariat at SIAC does not do the work of case management at SIMC. So we have absolutely no sight of the matters that they're dealing with, the sort of work that they do. And even with the SIAC, SIMC protocol, the registrar refers the matter to SIMC. And beyond that, it's up to the SIMC case management council to take it up and deal with it as they are trained to do. So in that sense, there's absolute confidentiality between the two institutions, and in that way, the parties. I mean, it helps from reassuring parties that that information that might be disclosed during a mediation will not be revealed out in an arbitration. Even in that sense, an institution at the end of the day doesn't involve itself with any party, right? We are at the end of the day a neutral institution. So it's only up to the parties as to what they want to file and how they want to take it forward. In any case, an institution sort of maintains that it's a baseline for credibility.
Right. Well, thank you, Pranav. That was quite insightful. I have a question from a participant here, Mr. 𝗓𝗓 and in light of that, I have also an additional question on the same theme. So I would put that before, I would like to put that before 𝗂𝗏 and 𝗓𝗓. And so what the question is essentially is that how do you propose the institution will cover the language barrier of proceedings in India, a country like India? And in addition to that, what my question is that in a setup like India, in terms of low cost disputes or low margin disputes, which we see are multifarious in nature, in such a situation where an institution to maintain its quality, sanctity also has to maintain a certain cost aspect attached to it. Now, keeping that in mind, how do we tackle this issue, keeping in mind that we've already spoken about the great advantages of this, bringing it together? So maybe if we can take a note from 𝗓𝗓 first and then move to 𝗂𝗏.
This is something which is not new in India, and language, we have multiple language, but see, you need to look at what kind of disputes are you looking at, what kind of conflicts will get into where you need a specific language skills, and where you're looking at institutions. Now, one, you're talking about the large scale commercial disputes where invariably the language spoken or communication is through English. Then you go to your SMEs and disputes there. Then it would be English coupled with other languages. Now, what happens is if you look at mediation at a local skill set level, there are enough mediators available in India, qualified mediators, good mediators who understand local languages. The only thing is, the unfortunate thing is, we don't advertise, we don't know, so nobody knows who they are. They are around, there are several of them. So when you look at these kind of mediations, then there are already centers who are working in this field. So for example, if you look at Madhyam in Delhi, or you look at IIAM, which works around Kerala, etc., they're already into the field of community mediation, where you're talking about level community. And there are, again, international bodies which have also done community mediation in other countries where they work with local players. So they actually do co-mediations where you'll have the main mediator may not understand the local language, but you'll have several co-mediators who will understand. Then they have a mediation strategy that is adopted, where how the co-mediators who understand the language go out, speak to people, depending on what the initial brief has been between the mediator and the co-mediators. And then they come back, they again strategize and go back. So there are ways and means that are adopted even where the mediator necessarily does not understand the local language. Now, if you look at 𝗓𝗏, for example, 𝗓𝗏 does a lot of mediations in the banking, in the small scale for smaller disputes where the lender or somebody else may understand English with officers there, but the people who are eventually front-facing the mediators need not know any other language other than the local language. The mediators are then asked to know which are the languages that you can engage in. And then depending on where the matters are, you are then appointed. And these are all online dispute resolutions that happen. Even in a physical form, there will be enough mediators who understand the local language. So when you go to a court annex mediation center, or even with a private mediation center, you're asked to give languages that you understand. So if a party makes a request saying, I need somebody of a local language, then if the pool is there, you will choose people who understand the language. If not, then you tell the parties that, maybe you can suggest your own mediators. So it's not that India doesn't have mediators who understand the other languages. And that's the beauty of us. So I might, I sit in Telangana, while I can understand Telugu, etc., but I also can speak Punjabi fluently. So if there's a dispute between somebody who's in Telangana who understands Punjabi and so, I can mediate because I will be able to, if maybe not speak fluently, but I'll be able to get the gist of the entire thing. And maybe then I can work with co-mediators depending on what the dispute is. So then we strategize. So institutions work around these issues. These, I think, are non-issues to me because we have a pool of skilled mediators who understand several languages.
Right.
I think
Gsouhar, if you
Ekta
can shed some light on the topic.
yeah. Yes, I will just add that we were talking about the dynamic mediators who understand the need of the parties, and of course, a dynamic mediator would also understand the need of language of a party. And of course, co-mediation, as Ekta rightly pointed out, it is also very helpful. And generally, you will understand if you know Hindi or maybe a local language like he's in Telangana, if you know Telugu or any other language for that matter. If your mediator is dynamic and he or she can understand whether he has to converse, she has to converse in English, Hindi, or a local language. One way is that they know the language. Two ways they can always attach another mediator to the process and do it. But yes, I think we have a lot of options when it comes to communication and bridging that gap of communication. And it's possible more in mediation. Rather, if you put the same scenario in arbitration or rather in court, then what do you do? Because in court, in Delhi High Court or any other High Court, English is the language. How do you cure that issue in those courts? So at least we have an option of curing that issue when you are in mediation, and that's where Ekta has covered everything. I just wanted to add this one.
And in terms of the cost aspect, Gsouhar, what is your opinion on that? Considering that it might be like considering that the quantum of disputes and then the type of disputes that we might deal with within the premises of India.
So you would be, I don't know if you are aware, but mediation center attached to high courts are free of cost. If you know, if a mediation is successful in Delhi High Court, it is the mediator is given 1,200 rupees, and that is also not taken from a party. So that mediation is free of cost. I've not been part of many institutes, or I've not appeared before many mediation institutes outside of Delhi, barring Bangalore. But I have never paid a particular fee to a mediator for mediation, whether it is successful or not. So cost is a cost to be imposed to be incurred. I think it's a concept that will come in very late in the day. Right now we are more on how to attach a mediation center to a court and then somehow run it from the money that already is in the system. So I don't think cost is that big an issue, but in case the cost actually is incurred, I think it can. What one can do is it can be really minimalistic. Can also be based on the quantum of the dispute. Can also be based on some kind of a amount decided by the party. So, like in arbitration of course gives a particular schedule for fee. Mediation should not have a fee. Parties, if they are happy with the mediator, they can give whatever they want to. So I think that is how it will work, and cost effectiveness can only be brought when somebody, a formal institution, opens up ways and means for a mediation or a system like that to be attached to it. So I think cost can be managed or worked there.
Right. I mean, I understand the court annex mediation mechanism, but when we are talking about per se an institution, which, like I mentioned earlier, that which has to essentially conform with its standards, which have set it out, like infrastructure standards, so on and so forth. Basic essence for the redundancy of mediation in India is often that the lack of proper infrastructure, proper boardroom, proper case managers who basically manage and sit waiting areas and so on and so forth. Right. It is my understanding and my opinion also that let's say a sophisticated setup also gives rise to sophisticated opinions per se. So maybe a transition from that to maintain that there is a certain cost which is attached to, and also to make the quality or better quality of mediation per se. So keeping in light of that and keeping the mediation institutional mediation per se of so in that light, do you have to say something?
Only say, Anubhav, that when we talk about these institutes or institutions that would be dealing prospectively in mediation also, I would not be sending a dispute which is a brother's dispute on property or a family dispute between husband and wife to a institution like CAC. And a commercial dispute with parties who have a lot of money would of course be going there, and then there would not be a question on incurring costs. So I think we will have to see it from that perspective also, that a family dispute, I'm not saying it won't go, it shouldn't go, it should go, but I don't think that formalistic approach will be applied to a family dispute in comparison to what we will apply to a commercial dispute. And then fee, of course, becomes the second or the third factor, and resolution of dispute in a more sophisticated or a more scheduled manner is what becomes more important, and fee becomes second or third point of consideration. So I think my view would be that.
Correct. Thank you, Gohar. I think, Pranav would like to say something. Pranav, would you also want to take up family disputes at CAC?
I don't think SIAC rules would permit that, but I think insofar as costs are concerned, at least for commercial disputes, SIAC and SIMC as well has an ad valorem schedule of fees. So for parties that are looking at costs of resolving the dispute, A, you know your costs beforehand based on the value of the dispute. And B, if you look at the ICC survey on the actual costs, right? The cost of, that was conducted in an arbitration setting, but your costs of arbitration are very, very low. And even if you look at the SIMC schedule of fees in larger commercial disputes, the actual costs are quite low when it comes to mediation itself. So it's something that I'm sure institutions will do benefit out of giving their users some clarity on how much this is going to cost you. It's just on the value, and it acts as an incentive for mediators as well to try and resolve it as soon as possible, and not sort of stretch the process quite a bit.
Thank you. Shravan, do you also want to weigh in on that cost aspect, considering that you know?
So the cost aspect as such, for mediation, there is a separate costing. The administration fees and the mediators fees is now defined in the schedules appended to our rules. But yes, it would definitely be more cost effective, because I was a mediator in some cases where the parties, the substratum or the value of the dispute that is involved is quite high. So I did not have a basis as such to go back to when the parties have asked me what would be your fees. So it's just very it goes back to the pre 2015 amendment of the arbitration, where the judges used to really, I used to feel that the fees was very atrocious before the 2015 amendment, because if it was a Supreme Court judge, I really can't stress enough as to how I was put under tremendous pressure by the parties to substantiate why it is so expensive, and that was one of the main reasons why parties used to have a very bad idea. But when it comes to the Schedule 4 that is now available for us, it somehow, although not mandatory, it seems to be that's the norm of the day, because now people are getting aware, the parties, they'll say, why not Schedule 4? And the institutional, as an institution, we do have our own fee schedule, which we endeavor to maintain in terms of the Schedule 4. But the mediation, I'm just going to speak only about the mediation part of it. The mediation, there are two types of fees that we charge, probably similar to what SIMC would do, is we have administration fees, which is separate from the mediators fee. Now, the mediators fee is something that is dependent on the quantum of the dispute, and what we thought for fixing the administrative fees would be we really pondered a lot on how to come about that particular and then those discussions, we spent a lot of late nights on that to make sure that the parties do not get taken aback as to by looking at the fee part of it. But at the end of the day, you see the added value that the institution provides to the entire process if the institution is not being fairly compensated, I think you do not get some value addition would not happen to it. So I mean, I really think that when the resolution is going to be quick, the parties would really not look at the cost that is involved. Rather, you're going to end up spending a lot less in mediation in any case than any other, including arbitration, is what I would say.
Thank you, Shravan. Thank you, Shravan. That was indeed insightful. And I think I would like to believe that we've covered the length and breadth of mediation today. However, that might not be the case. I would be happy to open the question, the panelists to questions from the participants, if any. I think one of the organizers, Kushagra, had a question. And Kushagra, if you would want to ask your question.
Yes, thank you so much, Mr. Sarkar. And while I understand that you've already been speaking for so long, and I'm very grateful, I just feel that this is one question which I've had since this topic started. So as Mr. Mirza mentioned, that the High Court provides free mediation facilities, and institutions have a cost, which Mr. Unnam and Mr. Buddihal have confirmed. Do you, or would I be right in putting this controversial statement that it is the high courts or it is the government in general which is putting down the institutionalization of ADR mechanisms in India per se? Would that be a correct statement to put that way? Because why would anyone prefer institutions over a free mediation service? And that also highlights the benefits of institutional ADR per se. So I believe that anyone who could answer that question, I'd really be grateful. Thank you.
Kushagra, if I may answer that, if anybody would want to go first. See, Kushagra, what happens here is you're talking about, I mean, you should actually segregate different disputes into different, buckets. So there are commercial disputes involving, corporate entities or, rather individuals who are dealing with at a very high level of commercial nature. And, when I say commercial, I wouldn't want to get into that realm of what is commercial because it remains undefined in the Act as well as the convention. But yes, if there is an agreement in place between the parties, principal contract, which also contains an ADR clause, in such a situation, it brings about some sort of a professional element to it. And any resolution of a dispute would want to be done in a very professional manner. So there, it is absolutely imperative that parties understand the importance of having a streamlined, a procedure which would not bring about with itself some logistical issues. That's the last thing the parties would actually want it. I mean, when I say this, when I ventured into this entire arena, people used to ask me, my clients used to ask me, what is the benefit that you're... So the simplest benefits that I could actually come to, very simple benefits is, there is a case where I handled and the arbitration award was probably rendered in the year 2012 or 13 maybe. And for some reason, the award could not be traced back, and there is an execution. The enforcement is still underway, even after 4 years. Very unfortunate, but yes, that was the situation. And we were trying to trace out the award, and we went back. My party went back to the arbitrator who rendered the award and asked him for another certified copy of it. I mean, trust me when I say this, it is not possible to get it out. Because it's the retired judges, probably is almost 80 years then. And he really wouldn't know how to operate a computer. I mean, with all due respect, he had to take a lot of assistance, but still he could not locate the actual final draft, which was printed out and signed in front of the parties. And, the entire case set papers, which are submitted to the arbitrator, are often forgotten after the case is done. And is there a mechanism to, have some sort of a secretarial services? No, it is not possible. So all of these small issues are also, being addressed by institutions as such. I had a request from one of the AmLaw 10 law firms from UK, based out of UK, practicing out of UK, that they wanted to conduct an arbitration here in Hyderabad because the seat is allegedly agreed to be Hyderabad. And they requested that a truckload of files would actually reach Hyderabad a week before they would actually come, the councils would come. And they wanted a service from institution to only be engaged with the logistical issues of it. So, all of these would come at a cost, is what I'm trying to put. And these cannot be just taken so lightly. Now, your question of, why would the parties intend to pay for it rather than go for a free mediation that is being offered by the government? The answer is in the question itself, right? You would not really get the same side of practitioners being, fetching their time out of their busy schedule to actually act as a mediator and then give. So there is always a cost element to it. I'm only looking at it from a practical perspective. I'm not saying that free mediations do not have any value to it. Of course they do, and they would actually be very helpful to those citizens of this country who probably would not be able to pay a lot of cost to resolving a dispute. I mean, absolutely, there is a beauty to it, right? Free mediation. I mean, the IAM has been, as pointed out by Ekta, they did this community mediation sort of a model. And I mean, that was implemented in the state of Kerala. And I think, I'm not getting into the realm of politics or the gist thing, but it would be really, for a state of Kerala, I think it would probably be more easy to implement it as a community mediation, and the government would really back it up. But if you come to, situations like, developed cities, tier 1 cities and tier 2 cities, it's very impossible to do that. Community mediations would really rather diminish the value of mediations rather than make them more important.
Thank you. Thank you, Shravan. I think that is definitely, I mean, anything that you want in a systematic manner or with a definite quality attached to it has a cost aspect along with it.
Can I
think,
add to that?
Yeah, sure, Ekta.
So the thing is, if you look at it and we talk about court annexed versus, private mediation, and we say that, there's a cost involved, then you can say, the least such a larger debate is justice there only for those who can pay for it. So, and that's a debate I don't think we should actually get into. But if you look at even court annexed mediation, and you talk about court annexed mediation because of mediation centers, vis-a-vis, suppose you look at the Commercial Courts Act. The Commercial Courts Act actually requires the parties to pay, I think it's 15 or 30,000 rupees before they get into mediation. So if you look at court annex mediation, which goes through the regular civil courts and through the high courts, is there for free in most states. But when you look at Commercial Courts Act, and it says you pay, and it's a nominal amount, it's not a large amount, but it says still there you need to pay. Now, then you get into NCLT. NCLT says you can choose mediators from our panel, but it doesn't get into costs. It says parties agree and costs, or the judge will say what the costs are. So if you look even through the court system, it's not necessarily it's always for free. And again, if you look at when you have court delivery systems, etc., and you're looking at court annex mediations, it's for matters that are before court. Now, when you talk about private mediation and you talk about arbitration, when the courts exist, why are people still going for arbitration? It's still a choice of the litigants as to how they want to choose. Even if you are in court and you want to do mediation, while you could go for court annex mediation, you still need to consider that why would I go for private mediation when I have court annex mediation? Some of the things is, as I said, parties have the luxury of making a choice. That's one. Secondly, you get the choice of a mediator in private mediation compared to court annex mediation, which you might just go on a roster. You could have trust because sometimes parties just want somebody whom they can have a trust. And there are institutions which are providing private mediation in certain cases on a pro bono basis as well. So when you look at court annex vis-a-vis those mediations, it's again, about does the mediator understand, do I get a choice of a mediator? So then it becomes very nuanced. But having said that, there is a place for court annex mediation. There is a place for private mediation. Now, and what Shravan actually pointed out, that there might be disputes which are extremely complicated, which are very complex, and you need that relevant skill set to look at that dispute. And that expertise may not be there in court annex. So I would like to put it that if you want highly specialized people to be involved in the mediation, then it might be better to go for the private mediation rather than a court annex mediation.
Good.
Thank you. Thank you so much.
Thank you, Ekta. I think if there are no further comments on this issue, we can take questions from the participants. And if not, we can close the session for today.
So,
Sorry, Kushagra, you wanted to say something?
so, Mr. Sir. We are saying that since it's already 2 p.m. and some panelists would wish to leave, we could end the session for now officially, extend the vote of thanks. And if the panelists wish to stay back, since there must be some questions that need to be discussed, whoever can stay back, then we can continue further on, but we can end the session so that the panelists may leave.
So yeah, I mean, thank you so much everybody for joining in. I mean, I think we've been talking about mediation for about a good 3 hours right now, and that's and it's true to its essence of what mediation is, talking on for hours. No, but jokes apart, I mean, it was fantastic, enlightening at the same time, and I mean, and to have so many great panelists at the same time. I hope I was able to, pursue the task of Elizabeth VI's husband properly. But having said that, what I would like to end by is that, we were talking about aged mediators. So in one of the mediations that I was a part of, and what one of the mediators who was about 72, 73 years old said that, and it was a question which was posed to him and which had the word, should we change something? And he said that, Mr. Sarkar, how many mediators are required to change a light bulb? And we were of course taken aback, and we did not know what to say. To that he responded that it was a trick question. Mediators must not make a decision whether the light bulb needs changing or not. with that, I thank everyone. Ekta, Apurva, Dr. Sharma, Gohar, Shravan, Laura. Am I missing out anyone? Yeah, and Pranav, of course. Thank you so much for joining in. It was absolutely fantastic, discussing these issues with you, and I look forward to the session tomorrow as well. Thank you, everyone.
Thank you so much, Anubhav. You did a wonderful job. I think we ventured into some areas which we were not even expecting to. I hope this was a fruitful discussion. We thank even the students who organized this. It's a job well done. You need to give us a pat on the back. Kushagra and even Kabir. Good job.
Yeah, thank you very much. It's been a great session. I hope to see you all soon virtually.
And it was wonderful meeting every one of you. Look forward.
Yeah, likewise.
Thank you. Thank you very much. It's good to have a good interaction with our colleagues from India.
Thank you so much for the panelists.
Sorry, I think Dr. Sharma is saying something.
Yeah, Dr. Sharma is extending his
I was
regards
just saying
to the
thank you
panelists.
to all of you for this discussion.
Thank you, Mr. Rajesh Sharma.
Thank you. Thank you. Yes.
I think Kabir would be there to extend the vote of thanks officially to all the panelists and the attendees. And I believe, Mr. Pranav Budhyal, you had your hand raised. So after the vote of thanks, we could also address your thoughts on the issue. So, Kabir, over to you.
No, Kushagra, I mean, I believe we could do it now as well if Mr. Budhyal would like that. And with regards to the vote of thanks, I mean, there isn't much left to say. I would just like to thank all the panelists, Mr. Mirza, Ms. Bell, Dr. Sharma, Ms. Vishnoi, Mr. Urna, Ms. Jimenez, and of course, Mr. Budhyal for taking time out of their busy schedules and enriching us with their insights on a Saturday. I think I speak for all attendees when I say that the panel discussion was thoroughly engaging and had us put our thinking caps on. A special thanks to Mr. Sarkar for moderating the session so smoothly. It almost felt like it was scripted at one point, but I would like to assure everyone that these discussions were organic, much like how we all prefer mediation to be. And thank you for everyone who joined us today. We hope to see you for a second panel discussion tomorrow.
Thank you so much.
Thank you. Thank you so much.
Thank you. Bye-bye.
It was a wonderful session. Thank you so much, Anubhav. And
Thank you.
Kabir, thank you so much. Thank you for having us on this panel, and thank you for the lovely conversations. And of course, to all the panelists as well.
Thank you, ma'am. It was great having you.
Bye, everyone. Have a wonderful weekend. Bye-bye.
Bye, everyone. Good weekend to you all. Bye.
Yes, so Mr. Budhyal, you had raised your hand in regards to the previous question.
No, I think Ekta sort of covered the point that I wanted to make, that you have different buckets of disputes and different institutions and governments look at it very differently. So I wouldn't, it's not fair to say that the government is putting down mediation, or why would one party choose free mediation over institutional mediation that's paid. So that's all I wanted to add there. Yeah.
But if I may ask, why is it that institutions cannot take over marital disputes or any other disputes per se if there is a Chinese wall of confidentiality that's there? That's something that troubles me, and I think that also hinders institutionalization.
I think it's a mandate of the institutions. Like if you look at CAC, I think it's a mandate of the institutions. There are institutions who do marital
Correct. But
okay, but CAC, this is it. If you look at CAC, you cannot weigh CAC compared to another institution. CAC has been set up for a particular purpose. And correct me if I'm wrong, Pranav, because when you look at CAC, you think commercial, you think about high stakes mediation, you think about complex disputes. But there are institutions on the other hand who will do even matrimonial cases. Like if somebody comes and tells me do a matrimonial dispute, I'll do it. But at the end of the day, if I'm going through a CAC, I will not think about a matrimonial. Unless of course at some point, the matrimonial dispute is linked to an intricate commercial dispute. It's a husband and wife who are founders and the whole thing is married in it. Then probably CAC will look at it, but then it gets case specific.
Correct. But I believe my question stems not from CAC's rules, but my question stems from the discussion that was carried out by Mr. Mirza, who made a comment which was that he would not prefer his clients to go to institutional ADR mechanisms if it is a marital dispute. So my question is, do practitioners have this opinion?
No, I don't think so. I don't think we can generalize that way. So there are, like for me, like the other day I was speaking to another lawyer, and he's looking at a very high stakes matrimonial issue with partners who are probably very, very pressed in terms of confidentiality. They wouldn't want to go into a court annex mediation room. They would want to do it on their own terms, on their own turf. They will look at private mediation. And there are several such clients around who look at private mediation, even for matrimonial disputes. They do not want to, basically they say that in a courtroom and they have this perception that in a court annex mediation, it's still part of a court process. They don't want to wash their laundry there. They want to sort of sort everything out, go to the court, get their divorce through mutual consent and walk out of the courtroom. So they look at the court only for giving finality of the divorce granted, which is a legal requirement. But everything else, they don't want to get into the court system. So, but the thing is a perception that is there, that if it's a matrimonial dispute, I need to do it this way. If there's something else, there's a need to do it that way. I don't think the law says you need to do it in a particular way. The law is flexible and fluid enough to let you choose how you want to do your mediation.
Correct. I think it's all about perception, and that's what needs changing in India for starters. Thank you so much.
Just to add, sorry, Kushagra, there are institutions that do free pro bono mediations as well. If you look at CAMP in Bangalore, they run mediation sessions for the state consumer forum over there.
Yeah, I've participated in those from CAMP. So and if you look at CAMP does matrimonial disputes as well, and CAMP is one of the you look at CAMP, you look at FCDR, they do private mediations. And they do matrimonial mediations there as well. So it's not limited to only commercial disputes. So there are institutions, because see, in India, while you have you deal with domestic issues largely. So our mediators are equipped to deal with domestic as well as international mediations.
Correct, and in fact, it is also.
But if you look at Singapore, and you look at Singapore as how mediation is there, they have SMC, which deals with domestic mediation, etc. So when you're looking at international mediations, you're going into CAC and SIMC. But for domestic mediation, there's a different framework which is there, and which has been running for several years now. Correct me if I'm wrong, Pranav.
That's correct. That's correct.
And I think I personally also agree that institutions would be able to handle these domestic matters even better, because there would be no particular aspect of partiality or dependence that would arise in institutions, certainly so, as compared to a little bit of cost aspect, as Mr. Undam mentioned, that there is always a cost aspect which is attached, and no a practical practitioner would allot all of his time to a particular dispute when they're doing it for a free mediation, as is the court premises. Of course, I'm not putting a blemish on how the court process works currently, but I'm just saying that the institution would be equally better, and that is something that we need to forward to all so that the perception changes, so that this movement goes forward. Because
So in fact, Kushagra, have you read the Vidhi report on mediation and ADR?
I've read the
It is about Vidhi has come up with a report a couple of years ago where they've actually done a research on how court annex mediations are working. And you'll actually see the glaring numbers between certain states.
Mhm.
And you'll see that in some cases, especially when the matters get into, one is how many matters get into the mediation center. But once you get into the mediation center, there are some states which have a number of about 70% that get resolved.
Yes.
So you should look at that. But of course, then if you have others which will talk about 15-20% of the cases which even get successful. But it depends on how equipped the mediation centers are. And if you're talking about things like neutrality, that's a fundamental thing. So if you talk about a mediation center and saying that you're not neutral, the concept of mediation just goes out of the window. So, but yeah, see, so when you look at mediation and you look at a mediator, one of the things that you're told is, one of the things you have to be very conscious about is that all of us come with our own baggage. We all have our own biases. How do we learn to leave it outside the door and then walk into a room for a mediation? And how do you say that if my biases are going to impact the mediation, I need to gracefully withdraw from the mediation? Because I need to not only be neutral, I need to be perceived to be neutral as well. So both have to work. So I think that's one thing when you look at mediation, and those are things, a 40 years is going to tell you have to be neutral, you have to leave your biases. But how do you do it? That's another story.
Yes, ma'am.
Thank you so much.
That is a psychological dilemma that has to be solved, something that possibly goes beyond.
And there's some wonderful writers, there are wonderful things that you can actually hear. They're very, very, very good people who are speaking about these issues in terms of how you look at communication, etc. So yeah, there's a lot.
Thank you, ma'am.
Thank you so much.
Thank you. I think there's a question though on whether you need to pursue whether to pursue arbitration you need a specialized course. If I understand this correctly, and subject to, of course, Ekta's views as well on this, you can practice arbitration at any point, but it helps if you've studied it a little more, simply because at the end of the day it's part of litigation and dispute resolution strategy. So it would help to be trained specifically in arbitration, or it's also something that comes with experience. So you don't need a specific arbitration specialization, a degree in it to be able to do it. And there are great practitioners who don't have specialized degrees and yet are very, very prominent in the field.
And just Ahana, to add to that, there are a lot of arbitrators around who are not lawyers either. So you have, especially if you go to Institution of Engineers, you'll find there are so many technical arbitrators who sit on technical disputes and who do not have any degree of law. So it actually depends on how you view your vocation and how committed to you are to figure out how you want to deal with it. And after that, your reputation will talk about you. Your parties will come to you because of the experience of whom you've arbitrated or whom you dealt with.
Certainly, ma'am. Perhaps if Ahana really wants to become an arbitrator, she should write the judiciary exam because of the latent bias towards the judges in India. Yeah, but I think on that note, we can end the discussion here. Thank you, ma'am, and thank you, Mr. Budhyal, for sticking around.
Thank you, Pranav.
And also,
Thank you.
moreover, if you do have the time tomorrow, you can certainly join the same link for attending the session tomorrow if you feel like it. And
It's a lovely session, Kushagra, but my daughter is going to kill me. She's all of 9. So
No, we understand. No, we understand. It is only on us to inform you that is.
Yes. I know. I saw that. It's a lovely discussion. Some great panelists. So
yes,
there's some lovely people on that session. So
thank you, ma'am. We have even more panelists tomorrow, but
I know. So I've seen what the session is. I've seen who the panelists are, and I was like, oh God, that's lovely. Yeah. So you have some.
We'll have the recordings on YouTube anyway. So rest assured.
I'll probably check it out later. Yes. So then that's good.
Thank you so much, ma'am. Thank you, sir. Have a nice day.
Thank you.
Thank you, sir.
Bye.
Should we enter into a breakout room, or I believe the
We could end the
YouTube live.
session. We could end the
Okay.
session.
Yeah, we could end the session. Okay. But then what if you want to discuss